The senators and all in attendance will please stand and be led in prayer by the Honorable Lionel Spruill Sr., 5th Senatorial District. Following the prayer, all will please remain standing and be led in the Pledge of Allegiance to the flag of the United States of America by Lindley Griffin, Deputy Director of Committee Operations and Calendar Clerk.
Let us pray. Dear God, my Father, the Father of Abraham, Isaac, and Jacob, we come to thank you because you've been so good to us. Thank you, my God, because you allow us to see another day, to give you all the honor, glory, and praise. Thank you, my Father, because you're so great and so good, and we love you. We come this morning, therefore, to ask you to please bless those who are sick with this virus that we have. Ask you please to go into all the hospitals and touch their Father's name of Jesus, those who need your help right now. Ask your Father to please come to this place. Touch each and every one of us who are here. Touch their bodies, whatever it is that we may have in this place. Touch us, dear Father, because we know you're a way maker. Help us, dear Father, to work together, that what we do today, we would do to be pleasing in thy sight. We would be careful to give you all the honor and all the glory. In Jesus' name we ask these things. Amen.
The clerk will call the roll. All those in attendance will please record their vote aye. The clerk will close the roll.
You have a quorum, Mr. President. Senate Journal for Monday, March the 1st, 2021.
The senator from Tazewell County, Senator Hackworth, moves that the reading of the journal be waived. All in favor of waiving the reading of the journal will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 36, noes 4.
Ayes 36, noes 4. The reading of the journal is waived. The clerk will report any communication from the House of Delegates.
We do not have any, sir. Yet.
Thank you, Madam Clerk. The clerk will report a communication.
Commonwealth of Virginia Department of Elections, April the 1st, 2021. To the Honorable Clerk of the Senate, Susan Clark Shar. Madam, on behalf of the State Board of Elections, this is to certify that upon examination of the official abstracts of votes on file in this office and pursuant to Virginia Code Sections 24.2-680 and 24.2-681, it has been ascertained and determined that at the special election held on March the 23rd, 2021 for member Senate of Virginia District 38, T. Travis Hackworth was duly elected to the term ending January 9, 2024, to represent parts of Norton City, Radford City, Bland County, Buchanan County, Dickinson County, Montgomery County, Pulaski County, Russell County, Smith County, Tazewell County, and Wise County. Should you require anything further, please contact Dave Nichols, Elections Services Manager. And thank you for your assistance in this matter. Sincerely, Christopher E. Chris Piper, Commissioner.
Thank you, Madam Clerk. T. Travis Hackworth took and subscribed the oath prescribed by law on April 2nd, 2021 at 11 a.m. The oath and certificate of election have been referred to the Committee on Privileges and Elections. The chair recognizes the senator from Washington, Senator Pillion, for the purpose of making a presentation.
Mr. President, I'll rise for an introduction.
Senator has the floor.
Thank you, Mr. President. Today I rise to introduce Senator Travis Hackworth, our newest member of the Senate family from the 38th Senatorial District. Senator Hackworth hails from Richlands, where he and his wonderful wife, Angel, have raised their 4 children, Levi, Simeon, Seth, and Rebecca. They are active members of their community and deeply devoted to their faith, along with spoiling their 4 granddaughters, Jacqueline, Ariel, Ansley, and Aaliyah. Most recently, Senator Hackworth served 5 years as a member of the Tazewell County Board of Supervisors, representing the Northwestern District. Over the years, he's also served on a number of regional, local, and community-based boards in Southwest Virginia. Senator Hackworth's presence here restores us to our full membership following the tragic passing of our dear friend and colleague, Senator Chafin. Ben loved Southwest Virginia and the people who worked every day to make it the best place to work, live, and raise a family. As you get to know Senator Hackworth, I trust you'll find that he shares the same passion, and I look forward to working with him to continue Ben's legacy as we serve the people of the great Southwest. Welcome, Senator Hackworth.
Senior Senator from Fairfax, Senator Saslaw.
Mr. President, members of the Senate, I move that we suspend the rules, grant the privileges of the floor to a distinguished person.
Question is, shall the rules be suspended and the privileges of the floor be granted to a distinguished person? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The rules are suspended, and the privileges of the floor are granted. Chair recognizes the senior senator from Chesterfield, Senator Hashmi, for the purpose of presenting the distinguished guests.
Thank you, Mr. President and members of this body. I'm so delighted to welcome and present our guest, Deputy Director Elizabeth Vocal, Doug Miller, Dr. Jeremy Hoffman, and Calvin Allen. Science Museum of Virginia has long been a cornerstone of the Central Virginia community, and it's provided remarkable educational opportunities for all of Virginia's students. And recently, the Science Museum of Virginia has entered a unique place in our history of the Commonwealth because it has served the site, the location for our General Assembly. And this resolution, Senate Resolution 514, signed by every member of this body, is an acknowledgement of the wonderful support that has been provided by the Science Museum of Virginia.
Senate Resolution number 514, commending the Science Museum of Virginia. Whereas in 2020 and 2021, the Science Museum of Virginia, the Commonwealth's premier public institution of scientific knowledge, hosted floor sessions and committee meetings of the Senate of Virginia during the COVID-19 pandemic. And whereas the Science Museum of Virginia was established in 1970 and opened to the public in 1977 inside the former Broad Street Station building, which had previously served the Richmond community as a railroad terminus for nearly 60 years. And whereas since its opening, the Science Museum of Virginia has developed innovative educational programming, acquired impressive artifacts, hosted innumerable permanent and temporary exhibits, and carefully preserve the historic building's unique architecture. And whereas the Science Museum of Virginia has placed technology and experiential learning at the forefront, offering live demonstrations in laboratories, a hands-on makerspace, an IMAX dome theater, and a planetarium. And whereas the Science Museum of Virginia supports science, technology, engineering, and mathematics, education, and gives young people the opportunity to learn about a wide range of scientific disciplines. And whereas at the outset of the COVID-19 pandemic, the Senate of Virginia requested the use of a conference hall at the Science Museum of Virginia to ensure social distancing and adequate safety procedures during floor sessions from April 2020 through February 2021. And whereas the Science Museum of Virginia has hosted the members and staff of the Senate of Virginia through the 2020 Reconvene session, the 2020 Special Session 1, the 2021 Regular Session, and the 2021 Special Session 1 of the General Assembly, and whereas the Science Museum of Virginia has provided outstanding resources and support to the members and staff of the Senate of Virginia throughout this period, all while keeping the museum open and accessible to the public. And whereas Dr. Jeremy Hoffman, Chief Scientist, gave tours of the facility and offered many educational insights into the programs, exhibits, and operations of the Science Museum of Virginia. And whereas the staff of the Science Museum of Virginia has always been willing to help with a smile and a professional manner and has gone over and above to accommodate the members and staff of the Senate of Virginia, changing their work schedules to adapt to committee and floor session meetings, with special thanks to Matthew Forrest, Doug Miller, and Calvin Allen for their assistance to Senate staff in coordinating the day-to-day operations. And whereas the Science Museum of Virginia has contributed to good governance in the Commonwealth by helping the Senate of Virginia conduct the business of the people safely, transparently, and effectively, now therefore be it resolved by the Senate of Virginia that the Science Museum of Virginia be commended for its work to support the Senate of Virginia in addressing the unprecedented challenges of holding General Assembly sessions during the COVID-19 pandemic. And be it resolved further that the Clerk of the Senate prepare a copy of this resolution for presentation to the Science Museum of Virginia as an expression of the Senate of Virginia's gratitude and admiration for the museum's legacy achievements in service to all Virginians.
On behalf of us all here in the Senate, we want to thank you all so much for your extraordinary professionalism, for the work that you've done to allow the business of the Senate to carry on for over 400 years, now in our 402nd year, but that was made possible in these really extraordinary circumstances by your extraordinary leadership, your innovation. I think I speak for everyone when I say that it's been a pleasure and a privilege to be able to gather here with you in the Science Museum. You've kept us safe. You've allowed us to be effective in the work that we're doing on behalf of all Virginians, and you yourselves have sacrificed, along with your families, to allow you to be here and allow the government to continue to function. So I hope you will see this as a source of pride for you, for the Science Museum, and for the Commonwealth of Virginia. We give you our deepest and greatest thanks, and we have a resolution for each one of you. I would invite everyone to please welcome and congratulate our extraordinary leaders here at the Science Museum. Thank you all very much.
so much.
Yes, yes, you all did an extraordinary job. Yes. It all works well together, so that's the best. Thank you. No, thank you. It's been fun. Yeah. Thank you. Thank you. Oh, no, you're very welcome. Well, it's neat. Yay.
Welcome to the family.
Thank you.
You're welcome. Thank y'all.
I'll exit.
Calvin, how's your dog?
He's doing good.
Good. Thank you. Have you gotten a picture? Have you gotten a picture? Unless you would like one of yourself. I did a group. Oh, sure. Thank you. Thank you.
I gotta grab it.
Thank y'all.
Yeah, we all turned the
I know, it's automatic, and I was like,
Yeah. Where'd it go?
what happened to my Eagle Scout? No wine.
Senate will be at ease. Senate will come to order. The senators will please take their seats. Clerk will call the calendar.
Senate calendar for Wednesday, April 7, 2021. Senate bills with governor's recommendations. Senate Bill 1127.
Senator from Spotsylvania, Senator Reeves.
Thank you, Mr. President. Good afternoon.
Afternoon, Senator.
Members of the body, Senate Bill 1127, governor amendments, basically take the charitable gaming bill, allow a caveat for the nonprofits. I think there's about 46 of them that make over $40,000 a year with regards to the original guts of the bill, to extend that time out to allow the study that we're going to partake in this summer some more time to continue as is until we come out with our recommendations. I'd like to make the motion that we accept or adopt the government's recommendation. Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1127? Seeing none, the question is, shall the governor's recommendations be adopted? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 38, no 0, Rule 36-2.
Ayes 38, no 0, Rule 36-2. The Senate adopts the governor's recommendations.
Senate Bill 1221.
Senator from Arlington, Senator Favolo.
Good morning. Thank you, Mr. President.
Senator.
Mr. President, I move that the governor's amendment be agreed to, that the governor's recommendation be agreed to. Speaking to that motion.
Senators, the floor.
Thank you, Mr. President. What the governor's amendment does is it allows Prince William County, the city of Manassas, and the city of Manassas Park to have the option to continue to do the fine work they're doing in their public health department through a contractual arrangement with the state, rather than calling the local employees, some local employees, state employees. So by allowing the locality to treat all the employees equally, given that they're doing the same work and the same responsibilities, it really does allow the local governments to have a little more control over the delivery of services. Nothing that the state has required these jurisdictions to do will be changed, and in fact, there will be a slight savings. The underlying bill passed the Senate on a vote of 39-0. Again, I renew my motion that the governor's recommendations be agreed to. Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1221? For what purpose is Senator from Eastern Fairfax? Senator Saravel rise.
Speaking to the amendment.
Senators, the floor.
Thank you, Mr. President. Ladies and gentlemen, I'm going to ask you to vote against this amendment. And I've been thinking about the role of these health departments and how we provide services, especially in light of this pandemic. And I just want you to think about a couple of things. First of all, and I represent Prince William County, by the way, 120,000 people, and our delegation is kind of divided on this. But, this pandemic has now killed, according to the data we have, about 550,000 people and counting. If you actually look at increased deaths in America, they're up way more than what has been attributed to the pandemic. So there's actually, if you actually look at the death rate increase, it's probably closer to about 700,000 people that have probably been killed so far by this pandemic. And Fairfax County has had an independent health department along with Arlington now for a period of time. And, Fairfax has kind of chosen to go its own way. They have their own app for signing up for vaccines. And, for example, at the beginning of this, when we were having fights about what data to disclose, whether to disclose data of infections by zip code or by race and other things, Fairfax was taking a different position, putting out different numbers. And I would just submit that I think there's a difference between the routine services that health departments provide on a daily basis versus what they do in a pandemic. In a pandemic, it's very important that we have a coordinated, unified strategy. And we don't have 20 or 30 different strategies, 20 or 30 different apps, 20 or 30 different vaccine policies that we have, and that's why we have state control over these things. And so I think in the autopsy we do when this is all over, how much local control we have versus how much state control, how we handle pandemics versus regular services are all something we need to talk about when we do the autopsy, when this is all said and done about dealing with pandemics. But from my perspective, just giving a locality control because we're unhappy with what's going on is sort of overkill. And trust me, the Prince William Department has been a mess. The director has been unresponsive. They have a 25% vacancy rate. The people aren't paid enough. Corey Stewart, from my perspective, underpaid these people for years. And we're now dealing with the consequences of that. But I'm not sure just giving the locality complete control, and I know it's going to have to be negotiated over 12 months, it could be a memo, is really the way to go. And I wish I had thought more about this during session. I might have felt differently about this bill when it came through, but that's kind of where I am right now. And I think we need to take a more careful look at this.
For what purpose does Senator from Prince William County, Senator McPike, rise?
Thank you, Mr. President. Speaking in favor of the amendment.
Senator's the floor.
Thank you. The Board of Supervisors in Prince William have requested that in addition to the City of Manassas as well as the City of Manassas Park, all of the governing bodies have requested this. Right now, all three of those jurisdictions are served by one health department, and that collaboration would continue with the same MOU. As such, you support it, actually, to the exact point that Senator Serville brings up, is actually unified command. Actually, the jurisdictions and coordination could actually provide quicker, more responsiveness because they're local. They actually have better applicability under unified command to actually apply the resources and deploy those resources more rapidly versus going through a state agency, then back down to locality. There's been lots of coordination issues, but this is an important endeavor. You know, between Manassas Park, and Prince William, there's now 500,000 in population. There's different portions, both east, west, and different responsiveness that are required, and I think that's better handled from the local coordination. And again, this is the local MOU that's set up in other localities, and I would appreciate the body's support for the measure. And again, I represent solely Prince William County, Manassas, and Manassas Park, the jurisdictions that are impacted by the legislation, and I appreciate the body's support. Thank you, Mr. President.
Thank the senator. For what purpose does Senator from King George, Senator Stewart, rise?
Speak to the amendment, Mr. President.
Senator's the floor.
Thank you, Mr. President. Mr. President, I concur with the gentleman from Fairfax. Having looked at this, I think we were probably premature in voting initially for the bill for Loudoun, and this would add in Prince William County. But it's interesting to me, the governing boards, as the gentleman from Prince William said, and by the way, I represent a pretty substantial part of Prince William too. I think there are 5 of us in here that have parts of Prince William and maybe differing perspectives on this, but the local health district director wasn't consulted in this nor given an opportunity to give feedback on this, and I question why the governing board makes decisions like this without involving those that are actually doing the job. And so I have a great deal of concern. Like the gentleman from Fairfax, I believe we better take a look at this before we enact this legislation, because it's a pretty significant change, and I fear that there could be catastrophic ramifications. God forbid we ever have another pandemic or something like that, when you are splitting this control and direction and the state doesn't have oversight. So I hope at least some will vote against this.
Thank the senator. For what purpose does the senator from Southern Fairfax, Senator Barker, rise?
Mr. President, I rise to ask support for the proposal here from the governor.
Senator's the floor.
Mr. President, I agree with the senator from Prince William in terms of the impact of this. I think it is something that would be highly beneficial to the people within Prince William, Manassas, and Manassas Park in terms of the services that are provided. And what I can tell you is that this has been a long-standing issue in Prince William County, in that there have been high vacancy rates, as cited by the senator from Eastern Fairfax, that have existed for years. And the reason those vacancy rates have existed for years is because the payment salary rates that are provided under the state system that has been operating are inadequate are clearly not competitive with the job offers that are available to the individuals who have worked at the Prince William Health District offices there. Individuals who have been there have been siphoned away to the local hospitals, to other providers within the community, because the salary levels are clearly inadequate. What has happened in places like Fairfax and Arlington is that once they were operating separately, they have clearly increased the salaries and been much more able to be able to provide all the services adequately. This would help the locality in Prince William County and make sure that the people in Prince William and that area there, and will make sure that the opportunities are there to be able to provide adequate salaries. And it would be their responsibility, and they would be accountable for it. What has happened previously is that the local boards, as well as the state system, so we're not accountable on this, and we don't have to do anything to address this issue. This would make sure that the elected officials in the localities make sure that the services are there and salaries are adequate to provide good jobs for people in the Prince William area. And I would hope it would be the pleasure of the body to adopt this amendment.
Thank the senator. For what purpose, Senator from Rockingham, Senator Obenshain rise.
Mr. President, I speak to the amendment.
Senator's the floor.
You know, I walked in here without any notion as to how I might vote on this, but as I listen to the debate, what occurs to me is that, you know, we've got 4 jurisdictions, Prince William, Arlington, Alexandria, and Loudoun, who apparently perceive that the state isn't doing a good enough job of funding health districts in Virginia and health departments. These are 4 of the richest, most prosperous counties in the entire Commonwealth of Virginia who are capable of putting more money into their health departments. What it sounds like is that we have a real problem statewide, and the more prosperous counties we give this special treatment to, the less imperative it becomes for us to look at the systemic problem of making sure that our health departments around the state are doing the job necessary to protect our citizens across the Commonwealth of Virginia. And I suspect that once this is off of the radar of folks in Northern Virginia, which I'm reminded constantly constitutes about a third of the population of Virginia, it's not going to be a priority to fix for less populous and less prosperous counties in the Commonwealth of Virginia. So after listening to the debate, I think that we really ought to look at funding of health departments, look at the operation of health departments, rather than give the autonomy to the counties who can dump a lot of money into the health department and leave the rest of us around Virginia floundering and begging for the resources necessary to make sure that our citizens are taken care of. So while this might have been a good idea and might be a good idea, somebody apparently decided in the 6 weeks between session and now that it needed to be done and needed to be done now. I think we can wait until next year and maybe take a broader look at it. So I would hope we'd vote no.
Thank the senator. For what purpose, Senator from Arlington, Senator Favola rise.
If nobody else wishes to speak, Mr. President, I'd like to make a concluding remark.
Senator, the floor.
Thank you, Mr. President. I will just say that nothing in this recommendation changes any state standard, any state requirement, or any state expectation. So we will remain a state-supervised, locally administered health system throughout the state. Again, this merely enables local governments to align the salaries that are being paid, because they have some workers working right next to each other, getting paid a bit more because they're local employees versus a neighbor versus another employee who happens to be working for the state. Both employees are doing the exact same work. So this in no way changes the relationship in terms of work to be done, expectations, requirements to be met, and the standards that the state will set. So I just want to make that clear. this is optional local government, only local government that can use this according to this recommendation would be Prince William and the two cities that I mentioned. Again, I would ask that the body adopt the governor's recommendation. Thank you, Mr. President.
Thank the senator. The question is, shall the governor's recommendation be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? Clerk will close the roll. Ayes 20, noes 20. Chair votes aye. The governor's recommendation is agreed to.
Senate Bill 1245.
Senator from Bath, Senator Deeds.
Mr. President, I move that the amendment, that the governor's recommendation be agreed to.
Senators, the floor.
As the members will remember, this is the bill that does, among other things, allow for the drop boxes to be a permanent feature of elections going forward. There was a similar bill to this in the other body, House Bill 1888, which has been signed into law. The changes that were made in the House of Delegates did not make these bills precisely consistent, and this technical amendment, which was recommended by the Division of Legislative Services, simply makes this language consistent with the bill that's already been signed into law, and I'd ask you to agree to the recommendation.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1245? Seeing none, the question is, shall the governor's recommendation be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? Clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The governor's recommendations are agreed to.
Senate Bill 1252.
Senator from Prince William County, Senator McPike.
Thank you, Mr. President. I move that the governor's recommendations be agreed to. In speaking to the motion.
Senators, the floor.
Thank you, Mr. President. This is the bill in regards to the sunset of the coal tax credits. The governor's added basically a future intent of the General Assembly for future cost avoidance of what would have gone to VACITA through the tax credit mechanisms and dedicate that future fund to UVA-wise. I think the overall intent and message is, will those future savings be invested in Southwest Virginia? And the governor's sort of indicated a nod to UVA-wise. I don't have any objection to it, but I think as a body we should make sure that we have these future investments in Southwest Virginia, have it very thoughtful, and investments that are forward-looking. He's intentionally also identified areas of focus for UVA-wise in terms of data science, computer science, cybersecurity, and renewable energy, sort of future economic drivers for opportunities in Southwest Virginia, and hope the body will adopt it. I understand some in Finance and Appropriation may have some heartburn, as it does sort of create an intent of a Future Appropriations Act, which is not currently in our budget bill. But I hope the body still does adopt this measure. Thank you, Mr. President.
Thank the senator. For what purpose, Senator from Franklin County, Senator Stanley rise.
Thank you, Mr. President. Speak to the amendments.
Senators, the floor.
Mr. President, it's nice, to live in Southwest and Southside Virginia because it's got the cleanest air, the most beautiful people. Even right there in the back there. Ladies and gentlemen, if you look at the new senator, it looks like if Senator Chafin and Senator Carrico had a baby. But I digress. But they didn't have a baby, okay? It's not possible yet. So, ladies and gentlemen, I think we have all stood on the floor who represent Southside and Southwest Virginia, and I know the new senator will be one of those loud voices, just in the way that Senator Carrico was. And it's nice to be patronizing sometimes. It's nice to talk about aspirational things. It's nice to talk about historical things. Maybe in the future we'll do this, and what if we do this for you? But this is a non-binding wish list amendment. It's a feel-good amendment. It's an amendment that makes our governor think, see, I did something for Southwest Virginia, kind of maybe in the future. Because you and I all both know this is not binding on any single one of us. And today, as we welcome the new senator to replace one of the great statesmen who sat in this chamber, Senator Ben Chafin, who championed these tax credits, who worked hard on making sure that there were reforms in these tax credits. At the moment he's gone, so are these tax credits. With nothing more than a pat on the head to Southwest Virginia, maybe you'll get some of that money later for UVA-wise. No, we won't. No, we won't. You'll find another pet project for it. You'll find another way to send it to Northern Virginia. Because y'all don't care about Southside and Southwest Virginia. You don't. Then do something about it. 100% chance. Anybody want to make a bet at Rosie's that this money will go somewhere else and that it will not go to UVA-wise? Then I challenge you to put it there, but I know it's not going there. So I ask that you vote against this feel-good, meaningless, insulting, quite frankly, amendment. Thank you, Mr. President.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1252? Seeing none, the question is, shall the governor's recommendations be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 14, noes 26.
Ayes 14, noes 26. The governor's recommendations are not agreed to.
Senate Bill 1315.
Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that we accept the governor's amendments. And speaking to that.
Thanks, Senator. You have the floor.
Thank you, Mr. President. This is the bill that allows defendants to present evidence of a mental illness, autism, or intellectual and developmental disability in a criminal proceeding. The governor makes basically two amendments. One is technical, just adding a drafting error to the list of data that will be collected about such evidence that is presented. The substantive amendment changes, under the bill as passed, a judge could enter a temporary detention order if he felt that a defendant, such an order was warranted. The governor changes this to an emergency custody order because with an emergency custody order, there will be a mental health evaluation. If that evaluation shows that a TDO is necessary, a TDO can then be entered, but it just adds that extra step to make sure that there is a mental health evaluation, and I ask that we accept the amendments.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1315? Seeing none, question is, shall the governor's recommendations be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 25, noes 15.
Ayes 25, noes 15. The governor's recommendations are agreed to.
Senate Bill 1339.
Senator from Eastern Fairfax, Senator Servo.
Thank you, Mr. President. I move the body approve the governor's amendment. Speaking to that motion.
Senator, has the floor.
Thank you, Mr. President. Ladies and gentlemen, Senate, this amendment the governor's proposed basically does two things. Number one, the bill as written was interpreted by some people as inadvertently requiring the sealing of every single record that is within the CCRE. And so this makes it clear that we're only sealing records that a judge actually orders to be sealed, to make it crystal clear. That's the first thing it does, which is really a technical fix. The second thing it does is that it tweaks the reenactment or the enactment clause in the bill to say that if the state police certifies that their computer networks and all this stuff are all in place to electronically communicate with the clerks of court, local law enforcement, the Supreme Court, et cetera, that this new sealing system could go live before July 1 of 2025. The 4-year delay is giving a lot of people heartburn, and the state police felt like we ought to be conservative and giving them 4 years to get all the computer networks in place. And so this will allow them to speed it up. If they certify that they're ready to start taking this stuff, you could actually start to use this process sooner than otherwise as the bill was drafted. So that's basically all it does, and I'd hope the body would adopt the amendment.
Thank the senator. For what purpose is the junior senator from Richmond City, Senator Morrissey, rise?
Thank you, Mr. President. Would the gentleman from Fairfax County yield for a question?
Senator Yield.
I'll yield.
Senator Yields, you have the floor.
For the benefit of some of the members and also specifically for our newest member, this bill has been generically referred to as automatic expungement. The governor's amendment deals with sealing. Can you explain or articulate the difference between expungement and sealing?
Senator's the floor.
Happy to explain that. Probably wouldn't hurt for everybody to understand that. And we should probably stop using the word expungement because it's probably not really accurate anyway. But under our existing law, you file an expungement petition. And this bill creates an entirely new process. And the main practical difference between what happens when an expungement occurs and what happens when a conviction, not a charge, but a conviction is sealed, is that there's different levels of access. So when something's expunged, it's gone. And right now you can only get an expungement if you're not guilty. If something's just flat out dismissed, you're not guilty. It's gone. Once the order of expungement's entered, you can say, if somebody says, have you ever been charged with a crime? You can say, no, I have never been charged with a crime. If an employer wants to go look for it, they can't find it. It's gone. The only people that can access an expunged record is law enforcement. With sealing, however, under the bill we passed, there's a series of different categories of law enforcement, of employers and different categories of state agencies. And the Department of State Police also has to issue regulations refining that further that will allow certain categories of employers to actually look and see certain convictions that might matter in sensitive occupations. So, for example, if somebody's working in childcare, you need to be able to look and make sure that there's not a conviction that was sealed that might have a problem. People dealing with children, people in vulnerable situations, perhaps people dealing with money, those kinds of employment positions. And so sealing allows some employers to take a peek. Expungement disappears.
I thank the senator. Would the senator yield for one final question?
Senator Yield.
I'll yield.
Senator Yield, you have the floor.
Thank you. In civil litigation, would a party be able to have access to a sealed record? We know, as you just said, that CAs and certain employers would have access, but in strictly civil litigation, for example, one party wants to determine if the other individual had a criminal record for cross-examination purposes. Would a civil litigant be able to access a sealed record?
Senator's the floor.
Mr. President, I'd say I wish he had let me know he's going to ask me that question before right now. My recollection is sometimes.
Okay.
It just depends on for example, I know, in child custody cases, I believe there's an exception in the bill for child custody disputes. And there's also, for example, in some situations in criminal cases, the information that somebody was charged but it was sealed might be exculpatory and need to be made available to a defendant. So there's other types of evidentiary situations where you have to disclose that, and that's set forth at the end of the statute but not affected by this amendment.
Mr. President, I thank the senator.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1339? Seeing none, the question is, shall the governor's recommendations be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The governor's recommendations are agreed to.
Senate Bill 1356.
Junior senator from Virginia Beach, Senator Kiggins.
Mr. President, I move that the Senate agree to the governor's substitute.
Senator, the floor.
This the governor's substitute was purely technical in nature. The bill, as we agreed to, it was written in the wrong code section. So this substitute simply corrects that error and does not change any of the substance of the bill.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1356? Seeing none, the question is, shall the governor's recommendations be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The governor's recommendations are agreed to.
Senate Bill 1375.
Senior Senator from Fairfax, Senator Sasslaw.
Mr. President, 1375, as well as House Bill 2207, which we'll see later. The bill established a presumption of COVID causing the death or disability of firefighters, emergency medical service personnel, certain law enforcement and correctional officers, and regional jail officers as an occupational disease. If you remember the bill that I put in, the effective date of this was July 1st of 2021, this year. The House bill that Delegate Jones had was, the effective date was retroactive all the way back to March 1st of last year. We essentially settled on a compromise I had proposed of September 1st, because by the middle of the summer, virtually all of the groups that I mentioned had their PPE equipment. So the amount of cases had dropped dramatically in that profession. The governor originally wanted to take that September 1st date that I and that the House and Senate had agreed upon. He wanted to take it back to March 1st. And I told him that would have put far too much burden on local governments. And by the middle of the summer, as I said, most of them all had their PPE equipment, so the cases dropped dramatically. There still is some cost to local government, but we agreed as a compromise to make it July 1st. I could live with that. I haven't heard complaints from the local governments. The bulk of the problems that occurred in those first 60 to 90 days. So I would ask that you accept the governor's amendment or vote for the governor's amendment, which makes the effective date of this bill last July 1st.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1375? Seeing none, the question is, shall the governor's recommendations be adopted? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The governor's recommendations are adopted.
Senate Bill 1381.
Senator from Alexandria, Senator Evan.
Thank you, Mr. President. I move that the governor's recommendations to SB 1381 be agreed to. And speaking to that motion,
Senator, has the floor.
Thank you. This is the bill that has to deal with carrying a firearm or explosives within Capitol Square and state buildings. And we made some exceptions for people who were, for certain individuals who were acting in conduct of their official duties. And the governor amended the legislation for state buildings, not necessarily Capitol Square, for magistrates to carry a firearm. The bill already allows for magistrates to carry firearms into courthouses, but this amendment was requested by the Office of the Executive Secretary to protect magistrates working outside of courthouses and other government buildings. They are on duty in various locations at all times of day, working in sensitive and sometimes volatile situations, and magistrates are required to accept cash bonds and accept those cash receipts into a bank. So that requires the magistrate to frequently possess large sums of cash, both inside and outside the office, including during nighttime hours. So with that, I again renew my motion that we agree to the governor's recommendations.
Thank the senator. For what purpose? Senator from Rockingham, Senator Obenshain, rise.
Mr. President, speaking of the bill,
Senator's the floor.
First of all, this is a substitute. This is not an amendment. This readopts essentially the entire policy. And the senator from Alexandria makes a good point. There are people who have good reasons to be carrying a firearm in the vicinity of Capitol Square. And it's not just magistrates. There are people who work in banks. There are people who work all over Richmond, whose job carries them through or around Capitol Square. There are people who walk to work from areas that are less safe, who have good reasons to be carrying firearms. This is just bad policy, and by adopting this substitute, we're just reaffirming our commitment to a bad idea from the start.
For what purpose is the junior senator from Chesterfield, Senator Chase, rise?
Thank you, Mr. President. I rise to speak against the governor's amendments and this bill in general.
Senator's floor.
Mr. President, it really concerns me the attack on our U.S. Constitution and our Virginia Constitution. The Second Amendment is a constitutionally protected right, and I don't even know why we are introducing legislation to restrict law-abiding citizens' ability to protect themselves. Once again, there is an attack on our Constitution. I will be voting against any bill that has anything to do with restricting law-abiding citizens' ability to protect themselves, and I don't even understand why we are introducing legislation that goes against our constitutional rights. It is in the Constitution. Thank you, Mr. President.
For what purpose is Senator from Fairfax City, Senator Peterson, rise?
Mr. President, speak briefly to the bill.
Senator's the floor.
Mr. President, ladies and gentlemen of the House, and also those folks watching on video, I think it's important to note that my colleague pointed out that this title of this bill talks about Capitol Square, but it also refers to state-owned buildings and state-leased buildings, and that's where you would tend to find a magistrate. I'm not aware of any magistrate offices in Capitol Square. If so, I might need to get somebody bailed out someday. But just keep in mind, again, that this affects all state-owned buildings.
Thank the senator. Question is, shall the governor's recommendations be adopted? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. The governor's recommendations are adopted.
Senate Bill 1395.
For what purpose, Senator from Western Fairfax, Senator Marsden, rise.
Thank you, Mr. President. Having voted on the prevailing side, I would ask that we reconsider that vote so a member's vote can be counted.
Thank the senator. The question is, shall the vote by which the governor's recommendations were adopted on Senate Bill 1381 be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The motion is agreed to. Senator from Alexandria, Senator Eben.
Having previously explained the governor's recommendations, I move they be agreed to once again.
Thank the senator. The question is, shall the governor's recommendations be adopted? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The governor's recommendations are adopted.
Senate Bill 1395.
Senior Senator from Richmond City, Senator McClellan.
Thank Thank you, Mr. President. I move the governor's recommendations be agreed to.
Senators, the floor.
Thank you, Mr. President. This is the Voting Rights Act of Virginia, and the governor's amendments are purely technical in nature to correct a drafting error. There were certain places in the bill where the phrase covered jurisdictions was used but was not defined, and this just changes it to localities so that it's consistent throughout the bill with a localities is clearly defined in the code.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 1395? Seeing none, the question is, shall the governor's recommendations be adopted? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The governor's recommendations are adopted.
Senate Bill 1406.
Mr. President, could that...
Senator from Loudoun, Senator Bell.
Thank you, Mr. President. Could this bill go by temporarily? Be passed by temporarily?
Without objection? Without objection, Senate Bill 1406 will go by temporarily.
Senate Bill 1415.
Senator from Franklin County, Senator Stanley.
Thank you, Mr. President. With the recommendation that we reject the amendments, I now move that we accept the amendments and speaking to that motion.
Senator, has the floor.
Thank you, Mr. President. Senate Bill 1415, which passed out of this body, of course, addressed a specific issue with regard to child protective orders and family protective orders as we have in the juvenile courts. Specifically, what we're having was an inconsistency where if there was a violation of a child protective order, there was then a family protective order, it was a redundancy, and also it prevented, quite frankly, the ability to punish someone who violated a protective order by abusing a child. One of the most heinous things that you can do, I think, in life is hurt a child. And I think there are many attorneys in here that go into juvenile court and have these instances, these horrible, horrible instances, where there has been a violation of a protective order and has been in the abuse of a child. So what we tried to do is make sure in this bill, and this was Ben Chafin's bill, was to make sure that if there was a violation of protective order, one we removed by an abusive act upon a child, that we removed the family protective order, and we punished it not as a matter of contempt, which is a lesser punishment, but as a Class 1 misdemeanor in the violation of that protective order in the abuse of a child. Now what this amendment seeks to do is to kind of relitigate matters that we talked about already. We talked about, because there was a desire perhaps by one of these special interest groups that they wanted to remove from the first lines of the code section of 16.1253, remove actually that upon the motion of anyone regarding an act upon a child, if necessary, and these to create these protective orders to protect a child's life, health, safety, or normal development. That they somehow believe that this normal development, normal cognitive child development, is somehow unnecessary. And so that was rejected in this bill. It was rejected in committee. It was rejected when it was attempted to be amended on the floor. It was rejected by this body. When it came over from the House, that also was rejected. And in conference committee, we all determined that we were leaving it in. What this does is it goes down into the bill, and it's on the one I printed out around 114 to 120, where it says if there is a violation, and if that violation involves an act of commission or omission that endangers a child's life, but not the normal development, then it's a Class 1 misdemeanor, which would leave then childhood development, interfering with the child's development or abuse of a child by impacting normal childhood development would be nothing more than contempt. And ladies and gentlemen, I only have to give you certain examples that I've seen in a court of law myself, like Munchausen syndrome. Quite frankly, the CDC talks about impacts on child development and negative impacts on child development as actions taken by parents. We call it in my business abuse without bruises. Brain and cognitive development. There are people out there who will, by not maybe hitting a child or injuring a child, will take actions that will prohibit the cognitive development of their child. That's abuse. Emotional development, social development, academic achievement. All of these are acts of interfering with the normal development of a child, which this statute for years has protected against, because there are those things don't fit necessarily into the protection of the child's life, health, or safety. And that's the catch-all. So I'd ask everybody here to reject the governor's amendments in the same way, in the same manner that we rejected this during the regular parts of the special session. If we need to have a robust debate about this, then let us have that robust debate on a standalone bill, because that was not the purpose of this bill that the late, great Senator Ben Chafin was carrying. And so I ask that we reject, with the recommendation that we reject the amendment, that I move that it be accepted. Thank you, Mr. President.
Thank you. Senator. For what purpose is the Senator from Eastern Fairfax? Senator Servell rise.
Thank you, Mr. President. Speaking to the bill.
Senator's the floor.
Thank you, Mr. President. So, ladies and gentlemen, I would ask that you support the amendment. When this bill came through, I wasn't too excited about it in general, because basically what it does is it creates a new crime. It criminalizes new behavior. And anytime we do that, I always look at that kind of suspiciously, because I think for the most part, we've already criminalized enough behavior in the Commonwealth. I would note that if a parent abuses a child significant enough to cause harm to the child, we already have criminal child abuse statutes. We already have a domestic violence statute if a child's abused. And what this does is creates a new crime for violating a protective order. And one of the things you're supposed to do when you create a criminal statute is you have to define what's legal and what's illegal very precisely, so that people know where the line is before they're subject to being incarcerated for behavior. And courts sometimes will throw out statutes because they are too vague and ambiguous, and because a reasonable person can't determine where that line is, because often the standard can be in the eye of the beholder. For example, the Supreme Court of Virginia threw out the Virginia Beach noise statute a couple years ago, or actually it's about 10 years ago now, because it said you couldn't play your noise too or loudly that would offend like a reasonable person. And what's loud to you could be different than what's loud to me, right? And what this amendment does is it seeks to strike out of what constitutes a crime the words normal development. Because what types of actions could be deemed to affect a child's normal development is often in the eye of the beholder. Okay? I'm a vegetarian, right? All my kids are vegetarians. I've had people my whole life telling me, how dare you make your kid a vegetarian? It isn't going to screw up your kid, right? All my kids are, by the way, above average in height, but I've had people questioning some of my parenting decisions forever, right? And yeah, I see the senator from Fairfax. He likes to eat his animals. I get that. But that's the problem with this, putting this standard in a statute that creates criminal liability. So, for example, when you get a protective order entered that tells a parent, they have to take care of a child, if you create a statute that says they can go to jail for not following normal development, that means that a prosecutor that gets really unhappy with somebody, for example, could say, I'm going to bring a criminal charge against you because you're not taking your child to their regular well visit with their pediatrician, right? That's just one example, but I can think of thousands if we need to. We don't have time for that today, but the point is that type of behavior is more appropriately sanctioned by use of the court's contempt powers, not the state's powers to lock somebody up in prison. And that's the purpose of this, and that's why this amendment is supported by the Poverty Law Center, the Virginia Criminal Justice Conference, which is our neutral, independent body that makes recommendations to us every year from stakeholders about parts of our criminal code that need to be fixed. This is also supported by the Virginia Sexual Domestic Violence Action Alliance, the National Organization for Women and Families Forward, Legal Aid Justice Center, and about 15 Virginia prosecutors. So it's a good amendment that clarifies the bill. I think it makes it focused, and I think it also actually protects the bill from constitutional challenge, and I think we need to support it.
For what purpose does the junior senator from Richmond City, Senator Morrissey, rise?
Thank you, Mr. President. Would the gentleman from Franklin yield for a question?
Senator Yield.
I yield.
Senator Yield, you have the floor.
Thank you. While I always enjoy the senator from Franklin pontificating and speaking to the body, if it's possible to answer the following questions with yes or no, I would appreciate it. And
no.
Further question?
Would the senator, first question. Would the senator agree that the spirit, as he referred to, the late, great Ben Chafin's bill, is still encapsulated in this bill because it allows for a misdemeanor criminal offense if a parent physically abuses or endangers or in some manner creates some omission that hurts the child? Would you agree that that still is in the bill? The person can be charged with a Class 1 misdemeanor.
Senator, the floor.
Am I still stuck to the yes or no answer?
Yes.
No.
All right. Would the gentleman yield for another question?
Senator Yield.
No. Yes.
Yes. Senator Yield, you have the floor.
Given that the bill still allows a defendant to be charged with a misdemeanor if the person endangers the life or the health of the child, would you not agree that the language dealing with normal development is a bit vague and could include such things as what school to go to, All Saints Catholic School versus Enon Elementary? Would you agree?
No.
Okay. The gentleman can expand upon yes or no going forward.
No.
Would the gentleman agree that normal development could include whether the child could play contact tackle football versus flag football?
No.
Would the gentleman agree that normal development would include what particular religious education the child would have, Catholic versus Baptist?
No.
Would the gentleman at least agree that normal development may include whether the child, in addition to whether the child is a vegetarian, whether the child is vaccinated or not vaccinated?
No.
Final question.
Senator's the floor.
Thank God.
Would the gentleman agree that normal development may include whether the child goes to a traditional brick and mortar school versus stay at home and is homeschooled?
No. Senator's the floor.
All right. Speaking to the bill, Mr. President.
Senator's the floor.
I'd ask the body to accept and agree to the governor's amendment. First of all, we all agreed with Senator Chafin that maybe there should be more teeth than just a contempt if a parent endangers the child, and be allowed that parent could be punished with a Class 1 misdemeanor. Ladies and gentlemen, that still is embodied in this bill, including the governor's amendment. But the problem is this. When you talk about the normal development, it goes well beyond what Senator Serville said about vegetarian. It includes so many different things, some of which I just mentioned. And it still allows the judge to punish those things that I just mentioned as contempt, as opposed to punish them with a criminal offense. So if you vote yes to the governor's amendments, you are voting in favor of the spirit of the late, great Senator Ben Chafin, but you also are preventing from any criminal charges being brought against a parent merely because there's a disagreement between religiosity, vaccination, meat or pork or vegetarian. And so for those reasons, I'd ask the body to support the bill. Thank you, Mr. President.
Thank you, Senator. For what purpose does the Senator from Roanoke City, Senator Edwards, rise?
Mr. President, I can't really see you because there's a gentleman in front of me, but nevertheless, I guess maybe he'll move, maybe he won't. But, Mr. President, I rise to support the governor's amendment. It makes all of the sense in the world. We do tend to overly criminalize things occasionally, and there's a reason for the governor's amendment, and that is a doctrine of law known as void for vagueness. If the conduct that's sanctionable is to be criminalized, It must not be void for vagueness. It must not be vague. It must be clear that anybody can understand it. And what the governor's done is take out the language of this bill, perfectly good bill, that says that if somebody violates the protective order and the conduct affects the normal development of a child, how would you prove that? You'd need to have an expert witness. Is the child 8, 3, 14, whatever? You need to have, what is normal development? It's quite vague. That's the problem. As it stands, with the governor's amendment, without normal development, the language reads as follows. If the violation of a protective order involves an act or acts of, or commissions or omissions that endanger the child's life, health, or result in bodily injury, then it can be punishable as a Class 1 misdemeanor. Life, health, bodily injury. It's better that way without adding additional language, normal development. How would you prove normal development? It's very complicated to prove that. In my opinion, you'd have to have an expert witness come into court. It's already contempt of court anyway for violating a protective order. And to add this additional language compounds the problem and makes it a difficult bill, a difficult statute, and probably if somebody's being charged with violating a protective order and that the individual involved act affects normal development, it probably would be thrown out as void for vagueness, and therefore the governor is correct. Let's keep this a good bill without the additional language that the governor wants to take out, which makes the legislation problematic at best. So with that, I ask that the body support the governor's recommendation.
Thank the senator. For what purpose is Senator from Franklin County? Senator Stanley rise.
Briefly, Mr. President, just to close.
Senator's the floor.
First of all, I've listened to some lawyers that I respect very much here in the body in the chamber, and I don't know how much juvenile work that they do. But first of all, if they'd read 16.1253 without this bill, normal development is already in there. It's been the law for years and years and years. In fact, in the original code section, the first sentence says, upon a motion of any person or upon the court's own motion, the court may issue a preliminary protective order after a hearing if necessary to protect a child's life, health, safety, or normal development. So the senator from Roanoke has been either defending people on this or prosecuting people under this code for years, and it only now they find that the words normal development are included. This was not put in to this bill. Normal development is not new to the Virginia Code. And quite frankly, if you do practice law in the juvenile courts in criminal matters, you will see more often than not where a parent has a protective order against them. You know, they can't hit the child because that bruise will show up. Too obvious. They will then engage and embark on a campaign of interfering with the child's normal development to get back at them, or to continue to control them, or to punish them. Think about it. And so if they have a protective order against them for abuse, neglect, endangering the life, health, or safety, or normal development to begin with, they can't hit them. They can take actions to interfere with the cognitive development of that child, and they do it. There is no way to punish them except by contempt of court, 6 months, $500 fine. Not a Class 1 misdemeanor for abusing a child. That's the decision you're making. Not creating more crimes, as the senator from Eastern Fairfax says. Lessening the penalty for a parent or a guardian in loco parentis for harming a child. If you can live with that, then live with that.
Mr. President,
more importantly,
will the senator yield for a question?
Will Senator yield?
Mr. President, I will yield when I am finished.
Senator does not yield. You have the floor.
Mr. President, I would address everybody else and remind them that it seems like the junior senator from Richmond believes that all judges here in Virginia are bozos. Oh, wait. He might. We have to trust the judges that sit in juvenile court or those where the protective orders are before them to understand what interference or an act to interrupt the normal development of a child is, not just, your dad won't let you go to Catholic school? Well, that's a crime. So the examples that you're giving are ridiculous, with all due respect. But I love you. You know that. Or being a vegetarian or a pescatarian. That's not what this meaning of the statute that's already there means. But if you want a lesson, what we should do to some of the most awful people who abuse a child, if you want to lessen the penalty, then so be it, and you go agree to this amendment. And now, Mr. President, if he so chooses, I will yield.
Mr. President, with Senator Yield.
Senator yields for a question. Yes.
Isn't it a fact that it's already contempt of court only to do these things that you suggested, but it's not criminalized? And what the purpose of the bill is to criminalize part of it, to turn only a contempt of court into a criminal offense? Isn't that what the purpose of this is?
Senator's the floor. Mr. President, I answer the gentleman by that's exactly right. And if you have a protective order against you and you harm a child, it should be a little bit more than contempt of court when you violate an order of the court. It's a new crime. But why is it just when that crime is endangering the child's life, health, or safety? Should be a Class 1 misdemeanor, but not normal development. That should still stay as a contempt charge.
Further question?
Will the Senator yield for another question?
Senator Yield?
Sure.
Senator Yield, you have the floor.
Isn't it a fact that the judges have lots of powers when it comes to contempt of court? And that's the sanction involved, and that's what the statute currently has? And so what you're doing is taking part of it and also adding a misdemeanor to it?
Senator's the floor.
Mr. President, I answer the gentleman by saying contempt charges come with a maximum 6 months in jail, $500 fine. There's a due process issue, but it is not a Class 1 misdemeanor. So there's a difference between a contempt charge, a distinct difference between a contempt charge and Class 1 misdemeanor, sir.
Mr. President, speaking to the bill.
Senator's the floor.
The fact of the matter is when it comes to criminal matters, misdemeanors or felonies, the sanctionable conduct must be clear. That's why it cannot be vague. That's the reason for taking out the language from the misdemeanor part of normal development, which is vague. The others are not. Life, health, or resulting in bodily injury. That's what the bill is, to turn it into a misdemeanor in addition to contempt of court. I think we've exhausted the discussion here, but I think the governor's correct in making sure the bill is not thrown out from the standpoint of the criminal part of it as being overly vague. Thank you, Mr. President.
Thank you, Senator. Do any other senators wish to be heard regarding Senate Bill 1415? Seeing none, the question is with the recommendation that it be rejected, the question is, shall the governor's recommendation be adopted? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The Senate adopts the governor's recommendation.
Senate Bill 1436.
Senator from Augusta, Senator Hanger.
Thank you, Mr. President. I move that the governor's recommendation be adopted.
Senator, the floor.
Thank you, Mr. President, members of the Senate. The governor is just recommending that we add the emergency clause to this particular bill. The underlying bill requires the health department to create a health care provider reserve directory for use when there is a health emergency. The governor liked the bill and thought that it may be of some use during this current pandemic, so that's the reason for adding the emergency clause. Thank you.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 1436? Seeing none, the question is, shall the governor's recommendation be adopted? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The governor's recommendation is adopted.
Senate Bill 1457.
Senator from Eastern Fairfax, Senator Servo.
Thank you, Mr. President. I'd move that we adopt the governor's recommendation and speaking to that motion.
Senators, the floor.
Thank you, Mr. President. Ladies and gentlemen, this underlying bill did not receive a single no vote in either chamber. Its entire journey through the legislature, basically what it does is it enhances the authority of a county utilizing the urban county executive form of government, which is one county right now, but could be others in the future if they so choose. It gives them additional powers on historic zoning overlay districts. And the county currently is going through an ordinance revision, and by adopting this emergency clause, it would allow them to avoid an entirely second proceeding. They could just wrap it in with this one. And so this just makes this an emergency, makes it effective as soon as we vote it through. I'd hope the body would adopt the amendment.
Thank the senator. For what purpose is the senior senator from Virginia Beach, Senator D. Steph, rise?
Mr. President, inquiry of the clerk.
Senators, the floor.
Mr. President, I'd like to ask the clerk if this would be considered special legislation since it specifically only deals with the county of Fairfax.
I don't make those decisions. You have to address the presiding officer.
Okay.
Mr. President, parliamentary inquiry.
Senators, the floor.
Mr. President, I'd like to see if this is special legislation since it only affects the county of Fairfax.
Thank the senator. We have your inquiry, and the Senate will stand at ease. their seats. The senior senator from Virginia Beach, Senator D. Steph.
Yes, Mr. President.
Thanks, Senator. The senator had made an inquiry with regard to Senate Bill 1457 and asking whether or not it constituted special legislation. And just to provide an answer and also to remind the body that during the session, the chair made the ruling that the underlying legislation was not special legislation. Today's vote only deals with the governor's recommended amendments, and per the Constitution, those amendments are to be voted on by a simple majority basis, and the amendments themselves are not special legislation, given that the underlying bill also is not special legislation. So I wanted to provide that answer.
Thank you, Mr. President.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1457? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 34, noes 5.
Ayes 34, noes 5. The Senate adopts the governor's recommendation.
Returning to page 5, Senate Bill 1406.
Could that bill continue to go by temporarily?
Without objection. Senator from James City County, Senator Norman.
Thank you, Mr. President. I object and would request that we take the bill up in this sequence before we move to other parts of the calendar.
Just to state where we are, there is an objection, and so the senior senator from Fairfax, Senator Saslaw.
Mr. President, I would move that we stand in recess now for 30 minutes, from 2:20 to 2:50.
Without objection?
Mr. President.
Senator from James City County, Senator Norman. If we could, Senator from James City County, Senator Norman.
Mr. President, as I rapidly approach the 3/4 of a century mark in my life, sometimes my recollection becomes very faint, but it's amazing. And when you get to be the age of Senator Saslaw and myself, you will find that sometimes you have a gap where you forget something, but then it comes back. And the initial thought I had was that I remember when the senior senator objected when my team wanted to take a recess. And my immediate reaction was, turnaround's fair play in this world, even in the game of politics. But then on further recollection, after about another 60-second gap, it came back to me that he had a moment of lucidity, an epiphany, and he backed away from that position. So I withdraw my objection. Mr. President, somewhere in there's a compliment, but I don't know where.
I think that's right. So the motion is to recess until 2:50 p.m. and without objection. The Senate will stand in recess until 2:50 p.m. will come to order. The senators will please take their seats. Clerk will call the calendar.
Senate Bill 1406.
Senator from Alexandria, Senator Eben.
I move the governor's recommendations be accepted, and speaking to that motion.
Senators, the floor.
Over the last month since we adjourned, we've worked with the governor to develop a package of amendments that strengthen this bill that are before us now as an amendment in the nature of a substitute. And the amendments fund public health and safety campaigns, as you'll hear in budget amendments later, speed up the timeline, create protections for workers in the industry, and simplify the process for sealing marijuana-related criminal records. And I'm going to go through them, a few of them now. One of the most significant amendments is ending the penalty for simple possession, allowing personal cultivation starting on July 1st. The governor's amendments move up the date of legalization of simple possession to this July so that we can get police out of the business of stopping individuals for having small amounts of marijuana. The amendments would make it legal for someone over the age of 21 to have less than an ounce as long as they don't have the intent to distribute it. The governor also recommends allowing adults over the age of 21 to be able to grow up to 4 cannabis plants in their homes. That's 4 plants per household, not per person. And as in the original bill, the plants must be out of sight of the public and out of reach of people under 21. Along with those changes and amendments, we make some updates to the criminal code to establish appropriate public health and safety guardrails. Those include prohibiting underage use, prohibiting possession while driving a vehicle, possession on school grounds, public consumption. And Virginia would not be alone in having legalized simple possession before legal sales. Colorado, Vermont, New Jersey, and just this week, New York made that same choice. There are some protections for workers that attracted some attention, and I want to be clear that these are for the 11,000 estimated jobs this industry will eventually create, and they do not conflict with our right to work law. Specifically, what the language does is it would allow, if reenacted next year, the Board of Cannabis Control Authority to revoke the license of a cannabis business if a company refused to remain neutral regarding any union organizing efforts by the employees, or doesn't pay prevailing wage, or labels more than 10% of their employees independent contractors. Those provisions, as I say, must be reenacted next year along with other sections dealing with licensing. One section that I want to thank the senator from Eastern Fairfax for calling to our attention was we eliminate the section of the law that allows removal of public officials for the use of marijuana. Also, it clarifies some of the sealing provisions. We made a decision as a body last year when we began sealing Virginians' records of simple possession. What this will do, similarly to as described by the senator from Eastern Fairfax in the sealing bill, is allow for more comprehensive sealings to begin on or before 2025, as soon as state agencies are able to make the needed updates. Over the last year and a half, we've made some significant improvements to our state's criminal justice system, and we have work ahead of us, but these changes help keep us moving in the right direction. I think that we agreed when we passed the bill during the regular session that the time has come for our state to legalize marijuana. These amendments ensure that while we're doing the complicated work of standing up a commercial market, we aren't delaying immediate reforms that will make our Commonwealth more equitable for all Virginians. And I'm available to take questions, but I will say that among the guardrails that we put in starting on July 1st were prohibiting using marijuana while in a moving vehicle, the underage possession, prohibiting possession of more than an ounce, and prohibiting public consumption on school grounds or while operating a school bus, and allowing adult sharing. That means transferring of less than an ounce of marijuana without remuneration. For example, if someone gave you a brownie today, they would not be criminally liable unless they sold you that brownie if it had something in it with THC. And there's a limit on carrying marijuana or marijuana products in a motor vehicle transporting passengers for hire. The prohibition on searches based solely on the odor of marijuana continues. Ban on commercial drivers possessing, and there's some penalties for cultivating for more than the limit of 4 plants. So with that, I renew my motion that the bill pass, the substitute pass.
Mr. President.
Full purpose Senator from Franklin County, Senator Stanley Rise.
Thank you, Mr. President. Would the gentleman from Alexandria yield for a question?
Will Senator yield?
I yield.
Senator yield, you have the floor.
Thank you, Mr. President. I'd ask my friend, the gentleman from Alexandria, from my research here, and especially that we're allowing 2 adult plants, 2 juvenile plants, that under perfect conditions, the yield for 1 plant of marijuana can be 17.5 ounces, which then, I'm not a math guy, but I think that's like 35 ounces for 2 plants. How do we reconcile the fact that you can grow 2 adult plants per household that yield then 35 ounces of marijuana, and then yet it is still outside of 1 ounce of possession? Then wouldn't that not be a crime in that you're possessing, let's say the yield is 35 ounces on those 2 plants?
Well,
how do we rectify that in terms of the criminal statute?
To answer the gentleman's question, first
Mr. President, I'd ask him, do you have to smoke 34 of those ounces first so you can get under the 1 ounce?
There's the floor.
First, I want to clarify that it's up to 4 plants, whether they're adult or not adult plants. I'm not an expert in how many ounces can be yielded after processing and the survival of the plants and so forth, but I think that you're overstating the number of ounces from a plant, but I don't know the exact yield myself.
Mr. President, would you yield for another question?
Senator Yield? Senator Yield?
Yes.
Senator Yield, you have the floor.
Mr. President, if I was to ask him that this comes from the incredible website called ilovegrowingmarijuana.com, and it says that at least 17.5 ounces of finished product marijuana, if just in 1 plant, then that is 16.5 ounces more than is allowed to be lawfully possessed under your bill. Are we not then also creating a criminal act by growing a normal yield in 1 plant or 2 plants, which is permitted under the statute?
Senator's the floor.
I'm not a cannabis agriculture expert, so I don't know that I can answer the gentleman's question to his satisfaction, but I'm not, and I can't vouch for that website or not, but I'll have to leave it at that. I don't have anything else to say to him on it.
I thank the gentleman, and I thank him for his brownies. I've had 4, and they are friggin' awesome. Thank you, Mr. President.
I can tell. Well, for what purpose does the junior senator from Chesterfield, Senator Chase, rise?
Thank you, Mr. President. I'd like to rise to speak against this bill.
Senator, has the floor.
Mr. President, I would like to speak right now on behalf of all the parents across Virginia right now who are gravely concerned about their young adults. I have 4 young adults, 25, 20, 19, and 22. What message are we sending to our young adults with this bill? Let me tell you the message that we're sending. We're sending a message to our kids that it's okay to do drugs in Virginia now. And as a mom of 4 young adults, I don't like that message. I think this bill is selfish. I think it's reckless. And I think it's irresponsible. And I'll tell you, there are a lot of parents of young adults across Virginia right now who I speak on behalf of today who want us to vote against this bill because they think it's bad, not only for Virginia, but also for our young adults. Thank you, Mr. President.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 1406? For what purpose is Senator from James City County, Senator Norman, rise?
Mr. President, speaking to the bill, sir.
Senators, the floor.
2 points. Mr. President, it's rather interesting to me that how the legislation started out with the legalization of certain amounts of marijuana and all of a sudden got a certain insertion on it in dealing with right-to-work law, which is really rather perplexing to me. I don't know why someone in the administration would deliberately attempt to derail this unless they had other thoughts in mind. It certainly occurred to me, Mr. President, as I looked at it, one, it points out the objection to an omnibus bill, and I acknowledge we've used them before. This bill covers so many aspects of so many diverse subjects that if one were inclined procedurally and understood the process, might even raise a question about the single object rule or the germaneness. But I say, Mr. President, that going with an accelerated date seems a little contradictory to me, and I understand probably no one gives a rip because of the pressures that are on getting this bill and that we have a governor who wants to contribute to the resurrection of his legacy. But we're going to accelerate the date. And I would say particularly to the members of the Senate Finance Committee, I'm having a real difficult time reconciling this. If you look in our sheets at budget number 14, budget amendment number 14, we are going to accelerate the enactment date of the legalization of possession of marijuana, but yet Budget Amendment 14 provides $1 million general funds in the second year of the budget for planning and implementation of evidence-based marijuana prevention and education programs for public health campaigns, including programs focused on youth and college-age population. So I say to you, Mr. President, we're going to enact this bill, and 1 year later, we are going to appropriate funds to educate our youth on the demons of marijuana. How in God's name can anybody reconcile the justification of accelerating the date, but we're going to hold the money back after it's been in effect for a year? Just absolutely unbelievable to me, Mr. President. And I know that my verbosity is not going to change the mind of anybody, but we really ought to think about the commonsensical contradictions of this, Mr. President.
Thank the Senator. For what purpose is the senior senator from Virginia Beach, Senator D. Steph, rise?
Thank you, Mr. President. Speaking to the bill.
Senators, the floor.
Mr. President, the original bill narrowly passed the Senate here in February 2019. Many of the concerns expressed by the members were assuaged with the suggestion that it would be 3 years before it would be implemented. We were told on this floor that we'll work it out. The regulations, the details, we know that's an issue. It'll be worked out. Thus granting the additional time to work on many of the area concerns that you're going to hear today and that we heard back in February. Mr. President, this 283-page substitute has 50,676 changes to this bill. I'll say it again so it can sit in. 50,676 changes to the bill we passed in February. Is there one member in this chamber who can say they read every single one of those changes and understand them? This may be one of the most complicated pieces of legislation we passed here, taking 2 full pages to list the code sections of Virginia being added, deleted, or amended. Mr. President, I not only think that we've not spent the time thinking about the ramifications of this, we're saying come July 1st that it's legal to smoke marijuana. When our police officers aren't going to have the training in time, because we're not funding it till 1 July, to test if somebody's driving while under the influence of marijuana and whether they're over the limit or not. Heck, we've not even established what that limit is. Mr. President, in a study in Colorado, percentage of marijuana users who admit to driving high within the last year, 70%. 70% of those users who smoke marijuana in Colorado drive while high. Self-admitted. Mr. President, it costs us between $40,000 and $60,000 to train a canine dog to detect marijuana and other drugs. Mr. President, do you think we can untrain one of those dogs to smell other drugs but not marijuana? You can't. So now we have to retrain and retire every canine dog out there that sniffs for drugs. Mr. President, I think this is another time where we're putting political expediency, we're putting political agenda over what's right for the safety and security of our citizens. Mr. President, the only way to tell if somebody's driving while impaired with marijuana is a blood test. These are expensive, time-consuming, and more invasive than just taking a quick breath test. You have to do a blood test. And Mr. President, imagine how many attorneys in here are going to discredit the individual who's taken the blood, stored the blood, transferred the blood, chain of custody like you wouldn't believe on these blood tests, and then argue what's going on. Mr. President, I think that this is one of the social experiments that we're doing here in this body that's going to backfire on us. And not only is this a bill that nobody's read in this chamber 100%, and I guarantee it, but it's one that we're going to jam back through 21 to 19, 20 to 19, whatever the number, and we're going to later regret what we've done. We're putting the safety and security of everybody on the roads in jeopardy. We're putting the safety and security of every one of our citizens, every one of our officers in jeopardy. Mr. President, I have more visitors come to our family-friendly resort city than anywhere else in the Commonwealth. And I can tell you, July 1st, if this bill passes, we're no longer a family-friendly resort. That goes away. 16 million visitors a year. We're no longer going to be family-friendly. Mr. President, I would hope that we would take the time to read, understand, dissect, and digest this bill, and not do it in the manner that we have so far. And keep in mind, we've completely rewritten 283 pages with 50,676 changes to the bill that passed this body just a couple of months ago. With that, Mr. President, I hope we vote no on this bill. Thank you.
Thank the senator. For what purpose is the senator from Arlington, Senator Favola, rise?
I'm speaking in favor of the governor's recommendations, Mr. President.
Senator's the floor.
Thank you, Mr. President. I just want to point out that these recommendations not only add additional and necessary guardrails, they also reiterate, I think in a very good fashion, a comprehensive process for managing the cultivation, the distribution, the sale of marijuana as we go forward, the requirement of having a good and robust public education campaign, and the language does include a campaign in our schools. We do have an overall advisory committee to the Cannabis Authority, and this advisory committee will be comprised of many stakeholders representing all different aspects of the marijuana issue, if you will, and we will have a public health advisory committee. So this is a topic that we are taking seriously, that we are attempting to manage, and I believe we will manage well, and it is something that I believe will move Virginia forward. And I, for one, believe that we have addressed a very important social inequity by adopting the governor's amendments, which actually will make marijuana legal come July 1. The governor also addressed the sealing of records question very well, and I think it is time. We can do this. And lastly, I will say that there is, I think, a very thoughtful allocation of the tax revenue we would be getting, and literally 1/3 of that tax revenue would go to substance abuse prevention programs, and a significant chunk would also go to early childhood education. So for those reasons and for many others, Mr. President, I hope it is the wish of the body to move forward with the governor's recommendations, adopt the governor's recommendations. Thank you.
Thank the senator. For what purpose is the senator from James City County, Senator Norman, rise?
Thank you, Mr. President. The opportunity to speak a second time. I think any of you that have been around long enough know that when I do a faux pas, that I own it, no matter how serious or minimalistic it will be. I misspoke and I misread, and the money for the $1 million on education will come in July. So I apologize for my misspeak on that. What I don't apologize for, Mr. President, is I've been around a little while, and I understand how some legislators can bring attention to themselves on critical issues by suggesting that I am going to wander from the position of the majority, and then at the 11th hour, that in exchange for future considerations, I will change my vote. And I understand that. That's just the process, and I don't say that with any degree of acrimony. It is absolutely the way it works. Mr. President, the next point, I want to raise a parliamentary inquiry as to whether or not the governor's amendments violate the single object rule and also the germaneness issue. In speaking to that motion, sir.
Senator, the floor.
Your Honor, if you look at the language from the substitute of Senate Bill 1406, I think there's a significant concern about the language that starts on line 7,295, if anyone managed to dig through it that far, which I doubt if anyone did. I recall during the session, one senator in a moment of passion said, just pass it and then we'll read it and figure out what's in there. But Mr. President, it's going to be a little more complicated than that, and if you would extend the courtesy to me, I will try to articulate my concerns, sir. Mr. President, if I may continue, you have to do a little interfacing. Under Title 40, Chapter 4, Article 3, dealing with Virginia right to work law, it articulates what the prevailing law is in the Commonwealth of Virginia. It starts out on line 7240, and I believe one of our fellow senators made reference to it, and that's line 7240, and what it does is that acts as a segue to enlarge the scope and intent of this bill that had nothing, let me emphasize, nothing to do with the legalization of marijuana. And I would remind some of the younger members of the body, I was one of the earliest, if not the earliest senator that advocated the decriminalization and the legalization of marijuana. I just didn't anticipate that it would be done on this accelerated time schedule and as pervasively as it is. On line 7240, and that's section 4.1900, it gives the grounds for which licenses may be revoked. And the senator from Alexander tries to bootstrap that into substantiating the remaining portions. But here's where we have gone that flies in the face of Virginia's right to work law. Your license can be revoked if you refuse to remain neutral regarding any union organization efforts by employees, including inquiring about cards. Line 7296. You can have the license revoked if you check the recognition and union access to employees and the payment of prevailing wages as determined on the next line by the U.S. Department of Labor, or classifying no more than 10% of its workers as independent contractors. What has that got to do with the legalization of marijuana, Mr. President? And then on line 7298, you can have the license revoked and such workers are not owners in a work-owned cooperative. I say, Mr. President, that we can look at this in a lot of different perspectives, but this is not even a subtle suggestion for the preparation of a collateral and meaningful attack on Virginia's right to work law. And if anyone in this body, Mr. President, and I saw you were very telegenic last night, sir, very telegenic. But I listened very carefully to what all 5 of the candidates for governor were talking about, and it was abundantly clear. It was abundantly clear, even from a former governor, what their intent was on right to work. Now, I appreciate that yesterday's audience, I probably was the only pretended Republican to watch it. I understand further it was an audience that was having the debate directed at the Democratic base as they come up on a primary, and that you've got to feed the core. You've got to throw the red meat out there, but yet you got to try to distinguish yourself. There's nothing distinguishing about this language that is totally irrelevant and detached from the legalization of marijuana, and I respectfully inquire of a parliamentary rule.
Mr. President.
Senator from Alexandria. I'm sorry, Senator from Eastern Fairfax. Senator Serval.
I have a parliamentary inquiry as well.
Senators, the floor.
Mr. President, I was looking through the legislative history of this bill, and I noticed that the version that escaped from the House of Delegates had this identical language that's offensive to the majority leader, the senator from James City County, on its version. And so it's been in the bill for quite a long time, perhaps not in the versions that escaped from our chamber, but would I be correct that the fact that it was included in versions from the other chamber would be at least one factor that you would look at in considering whether or not it were germane to this bill? Perhaps not a governing principle you would look at, but at least a factor that you would consider, that this is some new concept that just came out of the blue.
Senator from James City County, Senator Norman.
You know, I fully respect that when a new sheriff comes to downtown, that new laws and rules come into effect. But the senior senator and I have been here so long that we remember there used to be a very firm, if not strict, prohibition against referring to what the House of Delegates did or did not do on a piece of legislation that was before this body. For many, many years, it was not even allowed to be considered whether it was persuasive for or against a piece of legislation. But I realize it's a different majority.
Senator, we have parliamentary inquiries before the chair, and so the Senate will be at ease. Senate will come to order. The senators will please take their seats. So just to reset where we are, the Senator from James City County, Senator Norman, had a parliamentary inquiry with regard to Senate Bill 1406 and a specific set of provisions, and the inquiry was twofold. One was with regard to germaneness, the other with regard to the single object rule. First, with regard to the question of germaneness, wanted to relate to the body that it is the parliamentary practice of the Senate not to rule on questions of germaneness with regard to governor's recommendations or House amendments. That's the answer to the first part. With regard to the second part, the single object rule, the chair, having reviewed the inquiry and the bill, rules that the provision does not violate the single object rule. And with that, I think there are additional senators who wish to be heard regarding the bill. So I would call on the senator from Prince William County, Senator McPike.
Thank you, Mr. President. Just briefly, I appreciate the governor's substitute and some significant amendments, which the senator from Alexandria had touched base on, but one of which I just want to highlight that was of some debate, as you probably recall, when we were moving to adopt the conference report, and one of which is the legalization date as well as home grow. That is now fixed in the bill. There's significant objection on the other side of the aisle to those that are saying that government can tell you it's legal, but you can't do it. This substitute now fixes that. And I think we heard many of those who had those objections. This bill now corrects it. It also corrects sort of setting up the framework, which is, I think, a relevant point, which was also brought up in that debate, which was we're setting up a public expectation that something is legal, but it's not. Now, with the substitute, it is, if you recall that debate. So I think the governor and his team, and appreciate his conversations over the last couple of weeks, I think we have it in a much better posture to ensure that folks do not get caught on the wrong side of an issue of having less than an ounce. It does have provisions, and I think we do have to make sure we have positive public campaigning to ensure folks understand there are other provisions in terms of smoking in public places, having and smoking in school. There's other prohibitions that are in the bill that we need to make sure we do a good job at communicating. But overall, Mr. President, I think the key provisions and some of the key objections that we heard from the other side are now addressed, and hope we adopt the governor's measures. Thank you.
Thanks. Senator, for what purpose does the senator from Rockingham, Senator Obenshain, rise?
Mr. President, rise to speak to the bill.
Senator, has the floor.
You know, I appreciate the debate concerning the underlying issue, and, you know, I won't tread on that. We have spent an awful lot of time talking about this. I think it's a bad idea to do this that quickly. It is clear that we are unprepared to address the issues, particularly that are going to relate to children's, teenagers, adolescents, and the impact of immediate legalization for them. And I know that there's a little bit of money in the budget. I know that somebody's going to develop a program, but we're putting the cart way before the horse. But what I really want to talk about is the language that Senator from James City County highlighted on page 148 of this bill, lines 7,295 through 7,298. It's just it's four little lines in that bill. They deal with when a license for a manufacturer, processor, or distributor can be revoked. It says that it can be revoked if the business, these are businesses, privately owned businesses, their license their ability to continue to operate, to continue to pay their employees, to maintain control of their own property. And I'm talking about physical property. It may be a farm, it may be a dispensary, it may be a manufacturing facility. These are owned by real people, not by the government. But what this says is their ability to continue to exist, for the owner of that property to continue to be able to use that property in the manner that the government has allowed them to operate it, can be revoked in the event that that owner has refused, number one, to remain neutral regarding any union organizing efforts by employees, including card check recognition and union access to all employees. Well, let me talk about that part for just a second, okay? Access to all employees. Now, that doesn't sound bad, but just a couple of weeks ago, on March 21, the United States Supreme Court heard an argument in a case involving just that. In Cedar Point Nursery versus Hasid, the owner of a California nursery was compelled by California law to allow the United Farm Workers to trespass on their property. California law is much more specific than this. This law says refuses to remain neutral or refuses to allow union access to employees. It's pretty darn open-ended. California, at least, I mean, crazy laws you would expect in California. By the way, who on earth would adopt California law? Well, that's another issue. But the California law said that unions must be given access to a business property for 3 hours a day, 120 days a year, okay? At least they limit it. Here, we are saying businesses have to give access, presumably unlimited access, to private property to union organizers, presumably 365 days of the year, to trespass in order to solicit them to allow, to solicit their employees to unionize. That's just fundamentally wrong. It is antithetical to everything we stand for in terms of protecting the integrity of private property. Moreover, we're passing language, presumably, that very well could be declared unconstitutional, and I hope it is by the Supreme Court. But more than that, it's just horrible, horrible policy and a horrible intrusion upon private property rights of individuals and businesses in Virginia. The second thing that this does is says that it will permit the revocation of a license in the event that the business is not paying its employees what the government says they have to be paid. What the government says they have to be paid, not just the minimum wages that we passed this year and last year. This is another whole set of minimum wages that we're going to apply to these particular businesses, which I would submit is really discriminatory with respect to the owners and operators of those businesses. And I would point out that these wages are going to be different in different parts of the state. So, we were concerned about minimum wages hurting, for example, Southside Virginia, because they were going to have to pay the same wages as folks in Northern Virginia when they couldn't afford it. Well, what this says is that every dispensary, every farm, every manufacturing facility is going to have to pay their employees that Davis-Bacon federally prescribed U.S. Department of Labor rate. So what happens to the farm next door that's struggling to be able to hire farm workers, or the manufacturing facility that is struggling to employ folks to work the line in their facility. The second a marijuana manufacturing facility opens up, they may be paying $22 an hour or $40 an hour because the United States Department of Labor has arbitrarily set that prevailing wage rate at that level. And I will tell you, that's not outrageous, because pipe fitters in my part of the state, I haven't looked at it for a while, but the U.S. Department of Labor was saying that pipe fitters under the prevailing wage had to be paid about $60 an hour. So if you care in the slightest about property rights, if you care in the slightest about fairness, about protecting the integrity of individuals' right to control their own property, this is just horrible public policy, and I would hope that you would vote no on that basis alone.
For what purpose does the Senator from King George, Senator Stewart, rise?
Speak to the substitute, Mr. President.
Senator's the floor.
Thank you, Mr. President. The gentleman from Prince William just highlighted that the governor's amendments cure some of the defects of this bill, and I agree with him on that. And I'll tell you, that original bill was a convoluted mess. And there's just no question about it, and I voted against it because of that. It was a convoluted mess that would put a lot of Virginians that I represent in jeopardy. And I find myself in a frustrated position because even though I voted against the bill, I was prepared to vote for the vast majority of these amendments today because I think they cure a lot of the difficulties that that legislation had, and I believe that that is my responsibility to the people that I represent. And then I found out it was in a substitute that's unseverable. And I will tell you all, it is very frustrating to me because while I wanted to vote for those amendments, I cannot support a substitute that I believe very detrimentally undermines our right to work law in Virginia and is going to set a very, very bad precedent. And some would say, well, it's got to be reenacted next year, and that's true, what the legislation calls for. But once this is enacted, I believe it will be reenacted, and I fear that so many other industries you're going to see this same policy inserted into provisions, and it will destroy ultimately our right to work law in Virginia. So for that reason, I unfortunately will not be able to support the substitute.
For what purpose does the Senator from Eastern Fairfax, Senator Servell, rise?
Speaking to the bill.
Senator's the floor.
Sorry, the amendment. Thank you, Mr. President. First of all, if anybody wants it, I have a red line. It's only about 551 pages, but if you want to see the actual difference between the bill that passed and the bill, the amendments in front of you, I got it right here, red line in color. I haven't seen 50,000 changes, but there are a few. But in any event, I have a red line. Number one. Number two, I've never seen so much consternation over language that has no legal effect. Nothing we vote on today is going to do anything with regard to our right to work law or labor organizing or card check or anything else. It's subject to reenactment, which means we have to vote on it again before it becomes the law. So I hope the press doesn't write a whole lot about something that isn't going to be in the law, but maybe they will. Maybe that's the whole objective of this debate, talking about something that's not going to be effective, but it doesn't have anything to do with what's in this. This is going to be effective. What is going to be effective is the home grow language. Senator Prince William is correct. This gives people a legal opportunity to grow marijuana that they can then possess legally. Without that language, because there's no way to transport it across state lines, there'd otherwise be no other way to legally acquire marijuana. I would note that at least in the committee discussion that we had, they said that it would take somebody who's really good at growing to grow a plant that would generate over 16 ounces. Maybe there's some people out there that have a really green thumb, but I think most of the time people are not going to be growing 16 ounces in their home. But I would also point out I am vegetarian, and this will be a plant. But I would also point out that the bill, we have to be really clear about what we're doing. And I know last time in the last floor debate, the senior senator from Richmond got up and said, the press is going to report this inaccurately. They're going to say we legalized marijuana. And they're not going to say anything about 2 years from now or adult use or under 21 or anything else. And she was exactly right. The headline that came out was Virginia legalized marijuana. Let's be clear what this does. This bill legalizes the possession of small amounts, under an ounce, by adults in certain circumstances, and that's it. It doesn't legalize marijuana, okay? So I hope the media is taking note and correctly inform the public, because we don't need a bunch of people running around breaking the law. This is not going to generate some ganja fest at Jiffy Lube Pavilion out in the parking lot, because that is smoking in public. And just like you can't drink in public, you can't smoke in public under this. Okay? You also can't have it on school property. You can't have it in a school bus. You can't use it while you're operating a CDL. This treats marijuana identical to alcohol. Hope that's in your stories as well, because we need to make sure the public gets this right, or else myself, the senator from Franklin County, the senator from King George, are all going to be having a pretty good law practice this year with all the violations that come in. So let's hope the public gets this right. But the bill in front of you, the amendment in front of you, what it does is, I think, it does the right thing. And this is all the senior senator from Richmond's idea in committee. I'll give her all the credit for it. But if we are heading towards legalization, there's no point we need to keep locking people, or not locking people up, but charging people with civil infractions and costing them lawyers and fines and everything else if this is the direction we're heading. We need to just hurry up and do it now. And that's why I think this is the right policy, and I applaud the government for doing what he did. This bill, this amendment makes huge improvements on the policy that we passed during session.
For what purpose is the senator from Franklin County, Senator Stanley, rise?
That's right. Speak to the bill.
Senator's
Speak
floor.
to the amendments. Look, you know, it seems to me that what we've done here is create an imperfect monster, because we're allowing you to grow, have 2 mature plants. And okay, let's say you're not an expert grower, but you're growing 4 to 6 ounces of weed, which is more than the 1 ounce that's allowed in 4.1 1100. And that's in public, but there's also the possession of that weed, or constructive possession, in your home. And what really kind of bothers me is, so you've got a conflict there in laws. How are we going to resolve it? But also, in 4.1 1101, a person who's allowed to grow those 4 marijuana plants for personal use in their place of residence, they have to then, they shall ensure no marijuana plants visible from a public way. Take precautions to prevent unauthorized access by persons younger than 21 years of age. I don't know about any of you guys, but except probably in the Saslaw mansion, I don't know any property that any of us own that we live in that a child that lives in our house under the age of 21 does not have access in. So what happens then? Well, guess what? You jump down, you're going to have a criminal penalty for that. Unless take precautions to prevent is merely not anything with any teeth. Then what you're saying is, oh, wink, nod. It's okay if the under 21-year-old has access to your weed that you're growing in your house. What about constructive possession? Have we thrown that out the window? As we lawyers know, you know of it to the exclusion of others and intend to possess it. Knowledge of the substance in your house. Is that going to allow cops come busting through the door? Because now you're possessing a lot of marijuana, not the 1 ounce in public on your person. I mean, the road to hell is paved with good intentions. And this is what we've done. In our rush to do something this year, in the political jewelry store smash and grab of getting as much done as we can to put on a brochure before the election years come, what we fail to do is understand the total impacts that something at 30,000 feet sounds really good, but on the ground is really bad. And unless we control ourselves, then what we're going to be doing is passing a bill that is not only going to be confusing, but it's also going to give the police officers some kind of window in getting into your house. And it's also going to give children, or even young adults under the age of 21, access to marijuana plants that they never had before, because mom or dad has decided they're going to grow those 2 plants. So I think this is a bad bill. And I've heard wanting to limit my time. That is consistent with what we're doing here in terms of shutting off debate. But ladies and gentlemen, if you're going to do it, then do it as the senator from Eastern Fairfax said. This should be a 4-line bill. We are legalizing marijuana up to this amount. That's it. This is a mess. It's a mess. I urge you to vote against the amendment.
For what purpose is the senior senator from Chesapeake, Senator Cosgrove, rise?
Speak to the governor's recommendation.
Senator's the floor.
Thank you, Mr. President. You know, I was listening to the senator from Eastern Fairfax talk about the media getting it straight. Well, I hope they do get it straight because, yes, we're going to legalize possession of small amounts of marijuana. How that's going to be done, growing your own, I don't know. But this insidious bill takes a first critical shot at eliminating the right-to-work laws of the Commonwealth of Virginia. Those of you who have been in the Senate for several years can probably remember the senior senator from Fairfax talking about nobody wants to get rid of the right to work. Give me a break. Well, sorry. It's time for you to give me a break. This bill is a direct assault on the right to work in the Commonwealth of Virginia. It has no business being in this bill. It has no business being anywhere close to this bill. But I will guarantee, and press, get this right, you will see this insidious intrusion into almost any state licensing that's going to come out in future legislation. Ladies and gentlemen, this is a terrible bill. And I ask you, please, look at what you're voting on and vote no. Thank you.
For what purpose is the senator from Spotsylvania, Senator Reeves, rise?
Thank you, Mr. President. I don't mean to tread on everybody's time, but I just want to be very, very clear about what we're doing here. What we're doing, as was said earlier, is we're allowing us to pass a bill, and we're going to put a bunch of money behind it in education because we know what marijuana does. It's dope. It messes you up, gets you high. And what that high is going to have a causal effect. Let me read you what's happened in Colorado from the Rocky Mountain High Intensity Drug Trafficking Area Strategic Intelligence Unit. And what they do is they just gather data about what's happened since they legalized. So let me make sure the press understands these numbers because this is what we're going to have. Since recreational marijuana was legalized, marijuana-related traffic deaths increased 151%. So get ready, Virginia. We're going to kill more of our people, while all Colorado traffic deaths increased by 35. Since recreational marijuana was legalized, traffic death involving drivers who tested positive for marijuana more than doubled. More than doubled. The percentage of all Colorado traffic deaths that were marijuana-related increased from 11.43 to 21.3. They had an increase that shows 45% increase in a 3-year average. Here's a nice fact, Mr. President. Just Colorado, past month, marijuana use for ages 12 and older is ranked 3rd in the nation. I'll bet they're proud of that in Colorado. And it's 85% higher than the national average. So let's get real. What are we doing? We're passing weed. It's going to happen. I don't care, small amount, big amount, whatever. It's going to happen, and we're going to educate our kids after the fact. I just can't believe I wasted all that time in committee trying to put together a bill with a layout of 4 years to try to do the best that we can do and garner the best policy from those states who have legalized that haven't had the greatest part. And now we're just going to shove a whole new substitute in front of everybody and say, just pass it because it's good, because I want to have a legacy. I'm not voting for it. It's junk. Why are we doing this? I just don't understand why we do things like this. I mean, I do understand. I'm not stupid, but I just think we're making a wrong decision. Somebody's going to be accountable for those deaths as they hit the road. Certainly not going to be me, Mr. President. I would ask we vote no.
Thank the senator. if I recall, Senator from James City County, Senator Norman. If I recall, the senator has spoken twice already.
Mr. President, I spoke on the parliamentary inquiry and the germaneness issue.
Well, I was also going to say, I also recall the last time you spoke, you called the chair telegenic. Is that correct?
I did, and you were.
Okay. Well, then, Senator has the floor.
You were very.
Please proceed. Please proceed.
You
know,
you were
very
handsome. And, maybe your appearance. No, I'm not going to comment on the substance. Your appearance was great.
Thank the senator. Senator has the floor.
Mr. President, a couple of things. I am going to order a copy of the tape that started at 4:12 today, because I was intrigued about the eloquence on reenactment. This does nothing. Just pass it. I've been around a little while, and I have seen bills on reenactment, and let's see if there are substantive changes when we address those portions of the bill on reenactment. It escapes me why you would want to advance a bill, even under the guise of a reenactment argument, that is so horrifically flawed. Without pointing out any specific names, I actually know that some of my colleagues on the other side of the aisle agree that this bill is horrifically imperfect, that it has highlighted the problems with going with an omnibus bill, but yet let's move it forward. I suggest to you, Mr. President, that perhaps His Excellency, from medicinal purposes, had been taking or enjoying some marijuana when he offered these amendments. A couple of years ago, I went and spent a couple of days in Denver. And I went out there because they were having a symposium on all aspects of the legalization of marijuana, from regulatory provisions to enforcement to what the practical experience was. And it's very interesting to me, Mr. President, because I heard, and it's come up today, can't smoke in public. I remember at the end of the first day of the symposium, a group of us were going to walk 1.5 blocks to a nearby restaurant for dinner. And we came to an intersection where there were 4 corners. On 3 of the corners, in broad daylight with heavy traffic, 3 of the corners, there were groups of people puffing marijuana in public. And I don't say that as a criticism of Denver. That is a prelude of what is coming in Virginia. And you say, no. As I look around this body, most of us in here have had the marvelous experience of raising children. And we have been through those years of adolescence where we have done our best to provide parental guidance. And don't do this. Don't smoke. It's bad for your health. Don't drink. It's against the law. You could be taken into juvenile and domestic relations courts. And I know that I am probably the only parent in here whose children did not listen to me and consumed alcohol before the age of 21. I know that. So, if there is any expectation by you altruists who are so determined to make this part of your legislative legacy and advance it now, you think about that. You think about whether or not your children are going to not smoke marijuana when you tell them you can't do it until you're 21. And I say, Mr. President, other than taking alcohol out of individuals' homes, marijuana is probably going to be more accessible and is almost more accessible on the black market right now. So I say, Mr. President, if there's any expectation there's going to be compliance with parental direction and the youth are not going to ignore the law, I think that is very different. And finally, Mr. President, I'm always respectful of you. And while I take a disagreement with your ruling on the single object and germaneness, I am encouraged because it took 6 of them to outdo one of me.
Thank the senator. For what purpose is Senator from Northern Fairfax, Senator Howell rise?
Speaking briefly to the bill.
Senator has the floor.
I also have been a parent of 2 very adventuresome sons who now are in the enviable position of being parents worried about teenagers. But I would like to point out to the minority leader, the kids are already smoking marijuana. They're already doing it. And, saying that you can't do it one more time isn't going to make any difference to them. And to me, that's a non-starter of an argument against this bill, frankly. But I did want to say one of the reasons I support making it come into effect soon is if we don't, and we have to wait another 3 years, I'll be in my 80s before I can do legally what I was doing illegally in my 20s. Thank you, Mr. President.
And as one of the many lawyers in here who loves the senator, we appreciate her hypothetical remarks about what was going on in her 20s. So, are there any other senators other than the patron who wish to be heard regarding Senate Bill 1406? Seeing none, call on Senator from Alexandria, Senator Evan.
Thank you, Mr. President. Just to respond to a few remarks that were made, I'll try and be brief.
Senator's the floor.
First, I just want to reiterate again that this bill does nothing. The reenactment portion of dealing with fair labor practices does not interfere with Virginia's right to work statute. If reenacted next year, this bill does not force anyone to join a union or anyone to pay union dues. I want to assure the senator from Virginia Beach that no police canines will be forced into retirement. I want to address briefly from the senator from Spotsylvania that studies have shown clearly that legalization with appropriate oversight and enforcement has not increased car crashes, fatalities, increased crime, or youth use, according to the American Journal of Public Health and Justice Quarterly. The pre-recreational marijuana legalization annual changes in motor vehicle crash fatality rates for Washington and Colorado were similar to those for the control states. Post-recreational legalization changes in motor vehicle crash fatality rates for Washington and Colorado also did not significantly differ from those from the control states. And people have been using cannabis as a boogeyman for a long time, but written history tells us that people have been using cannabis since the 3rd millennium BC, possibly earlier from archaeological evidence. Cannabis is much less habit-forming than tobacco and can be less habit-forming than alcohol, certainly than opioids, and can be responsibly enjoyed. Unlike alcohol, which is routinely sold in lethal dose quantities at liquor stores throughout America, cannabis, regardless of potency or quantity, cannot cause death by lethal overdose. In fact, there's been studies that have shown that in states with legal cannabis that there's less of an opioid problem. Currently, the U.S. Food and Drug Administration regulates the production and sale of dronabinol, a pill containing 100% THC, the intoxicating component in marijuana. Several years ago, the agency rescheduled this drug from Schedule 2 to Schedule 3 because of its remarkable safety profile. Certainly some things will change, but they're not all for the worse. Cannabis does not have to be the boogeyman that some are making out to be. With that, I renew my motion that the governor's recommendations be agreed to.
Thank the senator. Question is, shall the governor's recommendations be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 20, noes 20.
Ayes 20, noes 20. The chair votes aye. The governor's recommendations are agreed to. The Senate will be at ease. Senate will come to order. The senators will please take their seats. The senior senator from Fairfax, Senator Sasslaw.
Mr. President, I move that we waive the reading of the communications from the House of Delegates.
Thank the senator. The question is, shall the reading of the communication from the House of Delegates be waived? All in favor of waiving the reading will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close. The roll.
Ayes 35, noes 5.
Ayes 35, noes 5. The reading of the communication from the House of Delegates is waived. Clerk will call the calendar.
House bills with governor's recommendations. House Bill 1800.
Senator from Northern Fairfax, Senator Howe.
Mr. President, I move that the amendments be placed in a block, and any senator desiring to remove an amendment from the block, please do so after the clerk has read the number of the amendment.
Thank the senator. For-purpose senator from Bedford, Senator Newman rise.
Mr. President, I move that the amendments be determined to be specific and severable, and speaking that motion.
Senator, has the floor.
Mr. President, in 1994, those of you that were here with me remember that we, in the Constitution of Virginia, solved a problem. And the problem, Mr. President, was that we were getting amendments and substitutes sent down from the governor, and they were packaged together in such a way that they were not specific and severable. To remedy that problem, the Senate and the House proposed a constitutional amendment in 1994 that cured that problem and gave to this body and the more numerous body the capability to determine for itself whether or not amendments are specific and severable. Mr. President, my concern, I make no mistake about it, is that I am concerned that we have an amendment within the block, which is item number 57. In some of your reports, it may be item number 2, that calls for an investigation of sorts in the parole board. Mr. President, I would ask the clerk's office if they would distribute an amendment that is available, that is item number 1, section 1-1, so that individuals can have that on their desk. Mr. President, the desire here is that we would have the opportunity to find that these amendments are not specific and severable, and that gives us the latitude and capability with our constitutional powers to cure the problem in item number 2. Mr. President, many of you have listened and heard, as there have been many reports about the parole board, the Office of Inspector General, the determination by the governor or the chief of staff has berated members of the Inspector General's office, that a employee that was given some accommodation and bonus was 8 months later fired for producing some reports. We don't have all the facts there. There are disturbing emails, Mr. President, that show that individuals involved determined among themselves that they were, quote, drunk with power, and some, as it related to probation, wanted more and more and more names before our time runs out. Mr. President, you take all of those items, and what we've heard from His Excellency, and we're grateful to have heard, we understand, and we want an independent investigation. An independent investigation. So what did we get? What we got in item 57, item 2, number 57, is the most limiting potential investigation that you could possibly have. And then it's deemed, in the language, an independent investigation. Just look at what is in that language. One, there's $250,000, which no explanation of where and why the money is $250,000 or up to. Number two, it says that we will only investigate the parole board's investigation of the Vincent Martin case, not the many, many other cases that have been subject of concern. I was shocked to see in there that there was no bipartisan representation on the investigation whatsoever. The governor wants to investigate himself. He wants the attorney general, which changed or purportedly changed the 13-page report to closer to a 6-page report, wants to be the selector. But there is not one Republican, not anyone in opposition that's allowed anywhere near this investigation. And I got to tell you, I struggled with this next one, and that is this. Because of the location of item 57, you ask yourself, why is it under item 57? There's a reason. Because all of this money in item 57 is paid for out of the Attorney General's office. Therefore, the Attorney General gets to involve himself in the contract for those people that are going to investigate them. So item 57 was a careful decision. It wasn't in the legislative power. It wasn't in the general appropriation. Those of you that are in finance understand how all that works. It matters where it goes. It was put into that particular section. It appears, from all indication, being in item 57, that the Attorney General will actually sign the contract with the individuals that's going to investigate. Now, Mr. President, what would be available to us, and I just wanted to, in all fairness, provide it to you, is an opportunity for us, if we vote that the items are not specific and severable, that the bill will go directly back to committee. I've informed the chairman that we were going to do this, and then the committee, the chair could hold a meeting. We could mold it immediately. We could bring it back to the floor. We could suspend the rules. I would encourage that we do suspend the rules, and we could have a new item 57. What would the new item 57 potentially be? It would be something that would be very, very clear and something you would recognize. It would say that the Honorable Chairman of the Rules Committee would appoint 8 members, Democrats. The Minority Leader would appoint 7 Republicans, most likely. It would require that all the meetings be held in sunshine. It would require that our subpoena power, which is available to us, be made available to the committee. It would give an end date. The end date would be September the 15th, and the funds that would be required would be very, very minimal. It would also open up the investigation to find out what happened in all the other cases, not just the Vincent Martin case, which has nothing to do with the statements of drunk with power, nothing to do with giving me more and more names. It would give us a true look at the laws that could have been violated and the policies and procedures that were ignored. And that's something that I think that we should want to know. Now, what would happen after this? If we did this, it would go back to the House of Delegates. They would accept it. And some of you may say, well, the House of Delegates is not involved in the investigation. Good news is that under the way the Constitution works, it anticipates that. It anticipates that by allowing us to go into a committee of conference, and then if we wanted to give the House some and give the Rules Committee chair and others the opportunity to appoint members, we could get that done. We can get it done, and we can get it done today. Now, some of you may say, that's inconvenient. We might be here for an hour or two, and you're right. But I think that this is something that we should do, not because it's convenient, but because we deserve to know. Mr. President, so that's the reason for my motion, that we find that the amendments are not specific and severable. I have made the motion that they are, but I would ask that you vote no on those items. Mr. President, I would like to yield to the senator from Spotsylvania who assisted in the drafting of some of the items.
Thanks, Senator. Prior to the Senator from Northern Fairfax, Senator Howe.
Mr. President, I am not an expert on procedure, and I know I'm very aware of that. But I do have a parliamentary inquiry.
Senator's floor.
Is not the motion before us my motion that the amendments be placed in a block, and that if any senator desired to remove them from a block, he could do so after the clerk called the number? And if that is the case, is this not premature?
Mr. President, I'm sorry.
Okay.
Mr.
I can either answer or the senator want to.
Mr. President, I will wait for your answer, sir.
Okay. I was just going to note that Senator Newman's motion would be a substitute motion to Senator from Northern Fairfax, Senator Howe's motion. So that's where we would stand there.
Okay, thank you.
Mr. President.
Senator from Bedford, Senator Newman.
Mr. President, I just want to make one point before I yield to the gentleman from Spotsylvania. I would never be disrespectful to the chair. And in fact, this is the only way to do it, because if we vote on one of these amendments, this motion is not available to us anymore. So that Tara has said we got to do it this way. Also, you could ask, well, why don't we just get out of this and ask the honorable chair of the Rules Committee to do this? And the reason is because the Constitution says we can't do that either, because today is only about these items, and so we don't have those options available, Mr. Chairman. So that's the reason why I've made the motion. So, Mr. President, with your ability, I would like to yield to the gentleman from Spotsylvania, sir.
Thank the Senator. Senator from Spotsylvania, Senator Reeves.
Thank you, Mr. President. I'd like to thank the Senator from Lynchburg as well for his eloquence and being a reasonable, prudent person. Mr. President, when this first kicked off, my colleague from Loudoun and I sat down and we said, we've got to do something. And Mr. President, we sent a letter and probably sent it possibly to the wrong committee chair to be heard. I'm not sure. I don't, know where we need to send letters. Not sure how it needed to go, but we didn't get any action. So the senator from Loudoun and myself said, maybe we should try again and send it to the chairman of rules. And we waited, and we waited, and we waited. In the meantime, Mr. President, I sat down with some pretty smart attorneys and figured out from the U.S. Senate and some other places in the General Assembly here, how can we go about putting a bipartisan commission together where it's fair and just and transparent for all the citizens of the Commonwealth to be able to see what's going on with the parole board and not limit it in any way, but allow that transparency. And Mr. President, the senator from Lynchburg has done an eloquent job of describing this process in his resolution, and that's what's stated in here. There's reasonable time for this to be done. It adds sunshine to what has been a cloud over not just this administration, but overall in the Commonwealth with how we are trying to move forward on criminal justice. People don't trust the parole board, yet they're still in power and they're still making these rulings. I mean, the simple fact, Mr. President, is it was a policy decision. They knew it wasn't going to be favorable to them, and they decided to circumvent the rules and the laws. And by doing that, it needs to be investigated. So we either leave the fox in the hen house, or we shine light on it. That's what this is, Mr. President. This is shining light on the fox in the hen house. And so what we've got before us is an opportunity to correct that in a bipartisan fashion, which this chamber has done a phenomenal job at looking at things that way. Mr. President, I would ask members to approve the resolution by the senator from Lynchburg. Thank you, Mr. President.
Thank the senator. Do any other senators wish to speak to the motion? For purpose, Senator from Rockingham, Senator Obenshain, rise.
Mr. President, I rise to speak to the motion.
Senators, the floor.
Mr. President, I join my friends in asking that the members vote no on the motion. And I would point out a couple of things. Number one, the scope of the investigation that the governor proposes is pretty staggering in terms of its limitations. You know, the disclosures that have been made over the past year really seem to cascade. They relate to not only the substance of the decisions, and, you know, we're probably never going to agree on whether certain people ought to be paroled, but the conduct of the parole board in covering up, trying to parole folks in violation of state law and in violation of its own policies are not even allowed to be considered in this investigation. This so-called investigation is not even of the parole board. If you read the language in the governor's budget amendment, it's an investigation of the investigation. It's an investigation of our supposedly independent watchdog. Who's ever heard of such a thing? I mean, this guy is appointed by the governor of Virginia. He serves at the pleasure of the governor. To suggest that somehow the inspector general intentionally threw an inside pitch and brushed the governor back is frankly absurd, or that the inspector general, whose report was gone over with a fine-tooth comb, presumably by the attorney general's office, that something would come out that was so biased or so inaccurate or misconstrued state law is absurd. But that's what this is investigating. It's investigating the inspector general, not the actions of the parole board, much less not the actions of the attorney general or the actions of the office of the governor, which in the most recent disclosures, there were some indications that there was express pressure put on the inspector general to change or to shade the findings in the report. You know, we need to look at it all and let the chips fall where they may. Everything ought to be fair game. Moreover, this is so carefully cabined that it doesn't even look at the investigations of the inspector general, and I think there have been somewhere near a dozen different investigations. But what this does is says we're going to spend $250,000 looking at one single investigation by the office of the inspector general, and that's of the Vincent Martin case. Now, why would that be? It's because that's the only case where they slowed it up and tried to fix the problems before Vincent Martin was released. As you may remember, Vincent Martin was going to be released without notifying family and without notifying the Richmond City Commonwealth's attorney. That was the first story that broke back in March of last year, more than a year ago. And the brakes were slammed on the release of Mr. Martin because of those oversights. And before he was released, they were able to rectify those problems. So why do you think it's limited to just the Vincent Martin case? Why not the cases in which there were no corrections, no remedial action taken? Why not in connection with the instances in which these most recent disclosures were somebody in the parole board was releasing hundreds of people from, or over 100 people from active supervision without contacting the local parole office and saying, I feel drunk with power, send me more, so we can get more people off of supervised parole. There are an awful lot of unanswered questions, and somebody was talking to our friends in the media a little while ago. I will point this out to you as well. If anybody hasn't noticed, it has an exemption from FOIA in there. So the handpicked, quote-unquote, investigator, Red Law Firm, which, by the way, will claim that everything that they do and find is protected by attorney-client privilege to begin with, but everything else expressly under the terms of this budget amendment is protected and exempt from the Freedom of Information Act. For those who believe that there's no here, and I know that there are people who feel that way, the best remedy is let's let the sunshine in. Let's take a look at this. If there's no here, it will come out in the wash. But for those who believe that somehow passage of this amendment, and I know that there are people down there on Capitol Square and certain office building who believe that the passage of this amendment is going to bury this story. And they are going to be sorely disappointed. I mean, this story isn't going away. When this report comes out at the end of June, I mean, we all know what it's going to say. I mean, we can write it right now. And I guarantee you, I will put it down in paper right now and we'll compare notes at the end of June with respect to what it says. And it will be exactly the same. But at the end of June, this is going to be a big story because it's going to appear to be a whitewash. And if you want this story to go away, let's really do an investigation as opposed to this sham that is being inserted in the budget. It will not go away. So I would hope that the senator from Bedford's request will be followed.
Thank the senator. For what purpose the senator from Eastern Fairfax, Senator Servell, rise?
Speaking to the motion.
Senator's the floor.
Thank you, Mr. President. I would hope the body would oppose the motion. And I just want to say a few things. First of all, what I think the ultimate outcome, the practical outcome of going this direction would be to make an independent investigation become a political one. I mean, I can't think of a better way to get politics into this situation other than putting a bunch of politicians in charge of the investigation. And that's effectively what's being proposed here. And I feel like every time there's a little movement on this, the goalposts keep moving. Every single time. Every time we come back, the goalposts move. Every single day we talk about this. And I don't think anything is going to satisfy the other side. Because from my perspective, this is largely motivated by politics and not policy. And we can have a conversation whether parole is good or bad. I'm sure some people here don't even think we should have parole for the people who it was constitutionally guaranteed to until 1995. But it is our policy, and it's not going to go away. The cases that are still there to be heard are tough cases, and the parole board does difficult work under difficult circumstances, and there will always be people who are happy or unhappy with their decisions. And I would say, Mr. President, that with respect to what's been proposed, I think that some folks are reading the language in the governor's amendment way too myopically, way too closely. The language directs an independent investigation of the Inspector General's, what the Inspector General did. The Inspector General looked at the parole board. By definition, that means the independent investigation has to look at what the parole board did. They have to. And I would submit that I spoke with the AG's office this morning, and I asked them what's the contract going to look like. They told me that the contract language in terms of the direction to the law firm that's hired is going to be exactly what's in this amendment. It's going to be exactly the language in this amendment. It's not going to be recharacterized or rephrased or reworded or changed. It's going to be exactly what we passed. Mr. President, I also spoke with the leadership of my caucus about what's been proposed. And if you'll note, the law firm or the independent investigator, it's going to be a law firm, but the AG's office told me it was their intention to propose a list of between 5 and 10 law firms who have an expertise in these types of investigations. This firm, it doesn't have to be a Virginia firm. There's many firms all over the country that specialize in these types of investigations. The firm is going to have to be selected with input right now, according to this amendment, from the Speaker, President Pro Tem, and the Governor's office. I've spoken with the leadership of my caucus, and they've advised that they're happy for the minority leader to also participate in that vetting process in terms of selecting who is going to do that investigation. I'm sure that's not going to satisfy everybody, but I would hope you would trust your minority leader to have input in that process, and that I hope helps a little bit, but it's not going to be enough, I'm sure. But I would also submit that there are reasons why there's FOIA protections in here. Because almost every FOIA protection that surrounds this whole process has been disregarded repeatedly by multiple people. And it's important that our laws about the confidentiality of information that's provided be honored. We have laws, we pass them, they're supposed to be followed. That's why they're in there. Mr. President, the last thing, we spent, how many days did we spend here last year? Right. And this proposal would have 16 or 15 of us spend pretty much the entire next month in session investigating all this. I didn't sign up to be in a full-time legislature. We need to leave it the way it is, let an independent firm do this investigation like they do all over the country regularly in all other types of legislatures. We need to reject the motion and just focus on the policy the governor's put in front of us so we can all get home tonight. Thank you, Mr. President.
Thanks, Senator. For what purpose, Senator from Bass? Senator Deeds, rise.
Parliamentary inquiry.
Yes.
What is the precise motion before the body? Isn't the precise motion to make the amendments separate and severable? And the senator from Bedford has requested a no vote. So if you want to support Senator Servell's position, you're going to vote yes. Is that correct?
That's correct. Sorry.
Mr. President?
That is correct. Hold on. Okay. No. Okay. All right. Let's reset really quickly. Just to recap, there is a substitute motion that's currently pending on the floor, and that is a motion to determine whether the governor's recommendation is specific and severable. So that is the actual motion, substitute motion that's pending now before the body. The question would be, and I'm not calling it yet, but the question would be, shall the Senate determine that the governor's recommendation is specific and severable? So I'll read that again. Shall the Senate determine that the governor's recommendation is specific and severable? If the yeas prevail, then we would proceed back to the Senator from Northern Fairfax, Senator Howe. If the noes prevail, then the bill would be returned to committee, if that clarifies the point. Junior Senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. This is a follow-up to the point of parliamentary inquiry. We have discussed for the last 20 minutes this independent investigatory committee, which, sidebar, might be a very good idea. But my question is this: how do we even get to that? Must we first vote to sever? And if and then only then we vote to sever, then do we get to discuss this document, a special committee of the Senate, which we have already been speaking about? Hold on, let me just...
Okay. I can answer your question, but Senior Senator from Fairfax, Senator Sasslaw.
Correct me if I'm wrong. The motion that'll be before us, the first vote, and maybe the only vote, would be to find that the governor's amendments are severable. Is that correct?
Correct. Specific and
All right.
severable. Correct.
By voting yes, you're supporting the Senate Finance's position and that position of Senator Howe. Is that correct?
Correct.
And that will be the first vote. If that vote is a no vote and that prevails, then you would move on to Senator Newman's. Is that correct?
No. That is Senator Newman's motion. If the no votes prevail on the question of whether it's specific and severable, then the bill would go to committee. And it's in committee where you could take up, to answer the junior senator from Richmond City's question, in committee you would be able to take up any amendments, including the one discussed by the senator from Bedford.
So if you're supporting Senator Howe and the Senate Finance's position, you would vote no or yes?
You would vote yes.
That's what I thought.
Correct. Okay. We're all on the same page? The junior senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. And I think we are on the same page. I understand. We all understand now if we vote yes, we are supporting Senator Howe's position, the Senate Finance Committee position. However, if we believe there is merit to a Senate committee, can we still vote yes in support of Senator Howe and still get that Senate committee of 15 members? And I have lots of questions to ask about that at a later date. Can't hear you.
Senate will come to order. The senators will please take their seats. The junior senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. I fully understand the posture in right now, but I would ask if the gentleman, senator from Bedford, Senator Newman, would yield for a question.
Senator yield.
I yield, Mr.
Senator
President.
yields. You have the floor.
I've read your document regarding the special committee of the Senate would be composed of 15 members. I see that they'd have subpoena power. Can you tell the body when the last time a standing committee of the Virginia State Senate or a special committee utilized this subpoena power?
Senator, the floor.
Mr. President, I know of it being done only twice. It may have been done more often. There was within the courts committee related to the crime commission, it has been done in the past. So the Code of Virginia specifically gives us those authorities, and so that's why we mention them here.
Would the gentleman yield for another question?
Senator yield.
I yield.
Senator yields. You have the floor.
I understand from this document that the witnesses not only could be subpoenaed, but they could be placed under oath. Does that also mean subject to the penalty of perjury?
Senators, the floor.
Mr. President, I'm being told that the answer is yes, but I don't know the answer to that. We can, Mr. President, just to have you understand, if we vote no, and I hope we vote no, we will take this into committee, and this is a proposal, my first draft, and those members that are on the committee or those people on the floor can make adjustments if 8 members aren't right or 7 members of each party or the process is not correct.
Follow-up question.
Senator yield.
I yield.
Senator yields. You have the floor.
Can you tell the body whether we have, in the recent modern era, subpoenaed witnesses and placed them under oath in order to pursue an investigation?
Senators, the floor.
Mr. President, I'm understanding that that was what we did with the Crime Commission. I do know, and speaking to the clerk last week, I think it is that that authority is given to us.
Thank the senator. Would the gentleman yield for another question?
Senator yield.
I yield.
Senator yields. You have the floor.
Can the gentleman tell us why this approach, a special committee of the Senate, would be preferable to going through either JLARC, which is a watchdog committee, or the Crime Commission?
Senators, the floor.
Well, Mr. President, we can certainly consider those items. One thing is for sure to the gentleman, item 57 is not sufficient. One, it limits what can be reviewed to what is already known. Then 2, it spends $250,000 and lets the Attorney General sign that agreement. It does not allow us to get into the questions whether or not the procedures of the parole board were followed either for parole board releases, notification to families, notification to victims. It does not allow us to understand whether or not the proper information was given out when we were doing releases from parole. So the scope is nowhere near correct. Number 2, I would say it is asking that we have a purely partisan investigation. And in my opinion, that's just wrong. Believe it or not, we're given the authority in this section of the code. It is something that's available to us. We should use it. And if not, let's take it out of the code is kind of my thinking. And number 2 is, should we not have, is partisanship the only method? And I kind of struggle with that partisanship should not be the only fair way to do it. Instead, bipartisanship is probably a more favorable way. So that's the reason why I propose this, but the General Assembly, if we follow through with the motion to vote no, can at least get to an other mechanism other than what's in item 57.
Thank you. Would the gentleman yield for one final question?
Senator yield.
I yield.
Senator yield. You have the floor.
The gentleman mentioned again the $250,000 fee and suggested that it would come from the coffers of the Attorney General. In other words, the Attorney General would use money in his budget to select that law firm to do the investigation. I've asked other members here, and they said that it wouldn't come from the Attorney General's coffers, but the decision on who to hire would be a decision by the minority leader, the majority leader, and perhaps others. Which is the correct and accurate version? Who would select this law firm?
So, Mr. President, it would be the governor and the attorney general in consultation with the speaker and the president pro tem. That's how it would be done. But don't overlook the fact it's in item 57. And you should ask yourself, why is it in item 57? Because it's the attorney general's pot of money. That's why I told the senator from Eastern Fairfax that when he signs the contract, it will be done in certain fashion. Because if you put it in item 57, it is in his lot of money. Therefore, he's the one signing the contract that is determined by the governor and the attorney general in consultation with the president pro tem and the speaker.
I thank it. Speaking briefly, Mr. President.
Senator, the floor.
Mr. President, I understand where we are right now, what the posture is. I will say this, though. I agree with all those comments, and I align myself with those individuals that said that the more sunshine, the better. Sunshine is a good disinfectant. However, I think we are premature right now. There may come a time when it is determined that a special select Senate committee or an existing committee needs exactly what Senator Newman says. But I don't think we are at that posture now, and I don't think we will be there until we determine that people whom this law firm needs to investigate aren't forthcoming. Are there any indicia of, not fabricating, but not being as transparent as we, the Senate body, would like? And so, while we still may, by voting today, yes, it doesn't, I would tell the body, it doesn't forestall the possibility that we may very well have to go down this special committee of the Senate route. Thank you, Mr. President.
Thanks. Senator, what purpose is Senator from James City County, Senator Norman, rise?
Thank you, Mr. President. I'm reserving my spirited comments in case the vote doesn't go as anticipated, but the recent series of questions raises two things to my mind. Give me a break. We want to do an independent investigation after we've had paid investigators render a report that we don't embrace. Give me a break. Number two, there's been some discussion about the protocol, and I think it's important to remind all of us, including myself, that if the investigation goes as currently articulated in this budget amendment and it is incorporated in the budget, be mindful, budget language overrides general law. So if there are any contradictions between what is in the explicit, not implicit, the explicit language that is in that budget amendment and other issues in general law, the budget language controls.
A senator from Northern Fairfax, Senator Howe. The senator. Oh, okay, no problem. Do any senators other than Senator Newman wish to be heard? Seeing none, Senator from Bedford, Senator Newman.
Mr. President, I'll be brief.
Senators, the floor.
I'm sorry the process is confusing. You have to vote no to get to where I want to go. I wish you could vote yes. It would make all the questions easier. If you vote yes, as the senator from Northern Fairfax wants you to, then you're doing that to say that the amendments are already separate and severable and they're good, if you think of it that way. So those of you that feel that way will want to vote yes with Senator Howe. To the senator from junior senator from Richmond, I appreciate his questions. They were questions of a truth seeker, and I'm grateful for those. But I will tell you that there will come a day where we have to have an independent investigation. And I'll tell you why. Because item 57 ensures it. It says you can only look in this small little area, like the gentleman from Rockingham says, that's already been investigated, that was already cleaned up, only look there and nowhere else. Mr. President, that's just not going to be okay. And to the items about whether or not there's politics in this versus others, I think you're smart enough to determine whether or not a single party, determined investigators, without the input at all from the other party, with one of those that has a conflict in that, the Attorney General's office, actually signing the contract, is that preferable to the openness of a committee that the chairman of rules and the minority leader set up? And the two are not even close. This will not go away here, and I'm hopeful that this Senate will do it. I assure you this, if we do, we can send this to committee, we can be out in 30 minutes, we can have an independent investigation, and then after that, we can waive the rules, we can be on our way. Time should not be a matter, but if it is to you, we can do it quickly. It will go to the House of Delegates, and they will decide on the matter. Mr. President, I appreciate on a fairly long day the Senate's willingness to take up this matter. I believe it's important enough to do it. Thank you, Mr. President. I hope you'll vote no.
Thanks, Senator. The question is, shall the Senate determine that the governor's recommendation is specific and severable? All in favor of determining that the governor's recommendation is specific and severable will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The governor's recommendation is specific and severable. That motion having been defeated, we will return to the original motion. It was the block motion from the Senator from Northern Fairfax, Senator Howe. The question is, shall the amendments regarding House Bill 1800 be placed in a block, and that any senator desiring to remove an amendment from the block will do so after the clerk has read the number of the amendment. All in favor of the motion will say aye. Those opposed, no. The ayes have it. The amendments are placed in the block. Senator from Northern Fairfax, Senator Howe. Madam Clerk, if you read the amendments.
Amendment 1. Amendment 2.
Senator from James City County, Senator Norman. I think your mic may not be on, Senator.
Sorry, I would respectfully ask Amendment number 2 be removed from the block.
Thank the Senator. Without objection, Amendment number 2 is removed from the block.
Amendment number 3.
Mr. President.
Senator from Roanoke County, Senator Suderline.
Can amendment number 3 please come out of the block?
Without objection, Amendment number 3 is removed from the block.
Amendment 4.
Mr. President.
Senator from Bedford, Senator Newman.
Mr. President, could item number 4 and number 5 come out of the block?
Without objection, Amendments 4 and 5 will be removed from the block.
Amendment 6, Amendment 7,
Senior Senator from Virginia Beach, Senator D. Staff.
Mr. President, can item number 8 come out of the block?
Without objection, amendment number 8 is removed from the block.
Amendment 9, Amendment 10, Amendment 11, Amendment 12, Amendment 13,
Mr. President,
Senior Senator from Virginia Beach, Senator D. Staff.
item number 12 and 14 come out of the block.
Without objection, amendments 12 and 14 will be removed from the block.
Amendment 15, Amendment 16, Amendment 17, Amendment 18.
Mr. President,
Senior Senator from Virginia Beach.
Can item number 18 come out of the block? Thank you.
Without objection, item number 18 is removed from the block. Question is, shall the bill be amended in accordance with the recommendations of the governor in a block? That is, all amendments except for the following: Amendments 2, 3, 4, 5, 8, 12, 14, and 18. All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The Senate has agreed to amend the bill in accordance with the recommendations of the governor in a block.
Amendment 2.
Senator from Eastern Fairfax, Senator Servo.
Thank you, Mr. President. I move the governor's amendment. Speaking to that motion.
Senators, the floor.
Thank you, Mr. President. Ladies and gentlemen, we've already talked about this a little bit. I'll try not to be redundant, but obviously the amendment provides $250,000 to conduct an independent investigation of the Inspector General's investigation of the parole board. This will be procured by the Attorney General with input from the governor, the President pro tem, and the Speaker. I already explained the process by which the person will be hired. Again, the minority leader is welcome to help vet the list of law firms to determine, make a recommendation as to who ought to be hired to look at this. It directs the State Office of Inspector General and the Parole Board to cooperate in the investigation. It also provides access to all records. It maintains state law's confidentiality with regard to the records that are to be maintained confidential under state law, pursuant to our Inspector General statute and the Freedom of Information Act, directs a report to be issued no later than June 15th. It's going to go to the governor, the speaker, the majority leader, the president pro tem, majority minority leader of the Senate. Everybody's going to get it. And, Mr. President, what I would say is that this amendment is exactly what has been requested for about the last 3 months. It's exactly what's been requested, is an independent investigation of this situation. While some folks might want to make this about policy, about parole and policy and who ought to be paroled, it's not. This is about process. And this investigation, this independent investigation, will allow professional investigators to determine whether or not the process that we have passed into law, as approved by the governor, has been followed. It is an opportunity for the parole board and the Inspector General's office and the Attorney General's office to establish that the process has been followed in all circumstances in this investigation. It allows everybody to establish whether or not there was undue influence in the process, Mr. President. And it will allow everybody a chance to show that this process worked, that our Inspector General system can work, which we set up in 2011. And, Mr. President, this investigation, coupled with the bills we passed this session, providing more transparency into the parole process, I think will help give the public more confidence in our parole board and the decisions that it makes. And, Mr. President, that's what this amendment does, and I would hope the body would adopt it.
Thank you. Senator, for what purpose is the senator from James City County, Senator Norman, rise?
Thank you, Mr. President. I rise to speak and request the body to reject the amendment, and I will try not to be too redundant.
Senator's the floor.
First of all, I would say, Mr. President, without engaging in hyperbole, that this issue has the potential to be the second most compelling definition of this administration since we went through the blackface situation. And I'll say that for a couple of reasons on it, Mr. President. First of all, I appreciate the collateral reference that the minority leader will participate. I apologize. In my advanced age, as I read the budget amendment, I don't see that referenced in there. So I appreciate the reference, but I find it salutary. Number two, I would say, Mr. President, if we look at the individuals who are participating in the selection of the law firm that's going to do the investigation, I believe someone earlier indicated this is basically a group that is investigating itself. And why do I say that? The language is pretty clear what the direction is, but we have the officer of the Inspector General. And so what was the ultimate reaction when the Inspector General's office was under verbal siege and met with the administration? Attack the whistleblower. Fire the whistleblower who just a few months earlier had extraordinary ratings and had received a bonus. You attack the source. I would say, Mr. President, further that we have the Attorney General's office that is involved in it and the Chief of Staff of the governor. Why is that important? That contradicts every argument of impartiality and independence, because the Inspector General and the whistleblower met, as I understand from the media reports, which you always have to be suspect of, but they met, the Inspector General, the whistleblower, met with the governor's chief of staff, they met with the Attorney General and the Secretary of Public Safety, which I have enormous respect for, but he has kept his head down on this situation. And Miraculously, after that meeting, the Inspector General's report that had been prepared by this otherwise exemplary employee was redacted from 13 pages down to 6. And there is not a person in here who would say that anyone other than that small cadre of individuals would have seen that 13-page report but for the whistleblower. What is interesting to me, Mr. President, is the chief of staff of the governor, who I think sometimes gets confused and thinks he is the governor. When the press conference was held about this situation, who was the spokesperson for the administration? The governor didn't stand up and defend it because his previous remarks was, I never saw the report. You know why he never saw the report? And this is fundamental internal politics. Because if his chief of staff and the attorney general and the inspector general met with the whistleblower, then the governor was not in the meeting, and therefore he has plausible deniability, and his chief of staff can stand up and say the governor didn't see the report. And the governor, with great integrity, can say that. But what really is remarkable, not only did the chief of staff attack the whistleblower, he attacked the Republican leaders who had received a copy of the 13-page report and said, we released it, and that was a violation of law. He may have a degree from Yale, but he ain't got a law degree, and that's pretty apparent why. The statutory provisions dealing with the Inspector General reports prescribes who is to receive the reports. Doesn't say they will receive a redacted report, says they will receive the reports. So what you've got is that small group from the administration determining what I would see as a statutory minority leader on that, and then get attacked for it. And the ridiculousness of it was that it was, in fact, the whistleblower and her attorney that had already put the unredacted report into the public arena through the media.
Mr. President.
I will not yield.
All right, I'll wait.
Senator does not yield.
I didn't interrupt you when you were on a roll, and you're not going to interrupt me at this point, my dear friend. So, Mr. President, that causes me some concern because there has been a circling of the wagons. And then we have the situation in the budget language which overrides statutory provisions saying these reports can be maintained confidential and exempt from the FOI. Gracious be, is that consistent? Or is it inconsistent with the behavior of the administration up to this point, who tried to release a 6-page rather than a 13-page report? So I ask myself, Mr. President, when we talk of the dreaded word that I've heard so many times, transparency, but sunshine on it, how in the world is the general public going to have any sense of confidence if, in fact, this report ends up being exempt from freedom of information, and because it's budget language, it trumps the statutory provisions that require it to be distributed to the majority, the minority leaders, I believe the President pro tem and Speaker. So I say the system is flawed, and I get no comfort from this absolutely fictional approach from the junior senator from Richmond and say, let's get the report and then we'll decide whether or not we truly need an independent report. Mr. President, I would suggest, as a number of our colleagues are sitting here, you might goggle the word independent and see what it says. See what the definition of independent is. And the independent is not allowing the parties who were implicated in this originally, the Attorney General, the Chief of Staff, and for partisans to pick the individuals that are going to do the investigation, because I know in another arena, that investigation is going to be undertaken exactly what they are directed to do by those partisans and the members of the administration. This is not good just on a partisan standpoint. This is a flawed, contaminated process.
President.
Would the senator from James City yield for a question?
Mr. President, with all respect, I will not.
Senator will not yield. For purpose, Senator from Eastern Fairfax, Senator Survey rise.
Will the senator from James City County yield to me?
well, the senator from James City County. I think he unplugged his microphone. Will the senator from James City County yield to the senator from Eastern Fairfax, Senator Servo?
Mr. President, I thought I was pretty clear, and I just was getting ready to adjust my my hearing aids again because I thought I heard an echo after I said no. I will say again, emphatically no.
Thank the senator. For what purposes, the junior senator from Richmond City, Senator Morrissey, rise.
Thank you, Mr. President. This, ladies and gentlemen, is a red letter day. I think it is the first time in the decade that I've been in the General Assembly that the senator from James City has not yielded to a question. So I would ask, in my addressing the senator's comments, is there anybody in this body, any Republican member of this body, who has any substantial information that when the governor's chief of staff met with OSIG, that they had the entire draft? If they do, interrupt me now. Mr. Speaker, I would also say...
Mr. President.
Senator from Bedford, Senator Newman.
Mr. President, to answer your question, we do not, and we can't under this. We have to have an independent investigation, and whether it's done now or it's done later, that's when we get that information. It's purposely written to where you have such a narrow investigation area that I say we will never get to that information.
Mr. President.
Thank you, Mr. President. Speaking.
Mr. President, if the senator's invitation is sincere.
It is sincere.
The senator has the floor.
I would interrupt. My recollection, and I do not have these reports in front of me, but my recollection is that the first report was addressed to the Secretary of Public Safety, and it bore a date in advance of the report that was ultimately released unredacted. So if you're asking whether there is evidence that a different report may have been presented to members of the administration, I would submit that as Exhibit 1, that there may have been a different report that was submitted to a member of the administration. Second, I would, as Exhibit 2, I would point out that the report that was ultimately belatedly produced to the President Pro Tem of the Senate and the Senate Minority Leader had a stamp on it, additional material that was not apparently on the original version, or at least the second version, the later dated version that went to the Secretary of Public Safety. We do not know when that was added. We don't know whether there were other things that were added or taken away. So, Mr. President, I submit that as Exhibit number 2, that there was a different report. I don't know whether it was substantially or substantively different, but the question was, is there any information that indicates that something different was submitted? And I submit those as 2 pieces of evidence that indeed there was.
Thank you, Mr. President. I'll continue now. And I appreciate
Senator, you have the floor.
I appreciate the senator's comments. First of all, ladies and gentlemen, the evidence is slightly overwhelming that when the governor's chief of staff met with OSIG. At that point, when he met with them, the 6-page report had already been issued. Nobody challenges that. Number two, there is not a scintilla of evidence out there that a larger pre-draft, what has been referred to as the 13-page report, ever made it to the chief of staff for the governor. There has been rampant speculation about that, and it has been in the form of points of personal privilege, but not a scintilla of evidence that lawyers like the esteemed senator from Bedford follows that any member of the administration ever got a 13-page report. And finally, ladies and gentlemen, it is not unusual for any state agency or this own body to issue a draft and then go through other iterations and come up with a smaller or shorter draft. At the end of the day, that's exactly what happened here. There was a draft made, and let's be clear, that draft was then examined by OSIG. They issued a final report, and it's 6-page. Anybody that suggests that the governor's office, the attorney general's office, or the chief of staff took a report from a state agency, zeroed out or crossed out the lines that they didn't want, and then resubmitted it as a shorter version is just absolute speculation. No evidence whatsoever. Thank you, Mr. President.
Mr. President.
Senator from Eastern Fairfax, Senator Servo.
Will the senator from Rockingham yield for question?
Will Senator yield?
Mr. President, every time I push this button to turn my microphone on, it turns my request to speak off, which backs me up in line, which really ticks me off. And I don't want to take a position contrary to the position that's been taken by my esteemed minority leader.
I think that's no.
Mr.
Senator will not yield.
Parliamentary inquiry.
Senator's the floor.
Mr. President, isn't it true that the Inspector General, Michael Westfall, signed an affidavit stating that he did not release the report to anybody in the administration? I'll withdraw the inquiry.
What purpose, Senator from Rockingham? Senator Obenchain rise.
Mr. President, speaking to the amendment,
Senator's the floor.
I want to say a couple of things. First of all, and I'll try not to regurgitate much of what's been said, but Senator from Eastern Fairfax or Southern Fairfax, I appreciate his comments. They, I'm sure, are consistent with the sheet of music that was issued by the Patrick Henry Building, and the sheet of music that's been that they've been singing from for the past 11 months, and I do appreciate those comments, and I think they were very true to that sheet of music. The senator, and one of the things that came up a little while ago was the suggestion or the recollection that the chief of staff for the governor excoriated legislative leaders for releasing that initial report concerning Vincent Martin. So, you know, let's talk about this very cabined investigation very briefly. I want to point out that notwithstanding what the chief of staff for the governor said, I remember very well the exchange that took place between the minority leader when he was provided the unredacted version of that report from the Office of the Inspector General. It had a designation printed in red that was not on the copy that went to the Secretary of Public Safety. It said, "This is confidential, do not release it because it has the potential to undermine a pending investigation." And the minority leader wrote back to the Inspector General and said, well, wait a minute. What is the statutory basis for that? I mean, the code says you're supposed to give it to both sides. And that's precisely the purpose for an inspector general, is so that there can't be a cover-up. That's why both sides are supposed to get it, so the light of day can shine on reports showing misconduct or corruption. And he did not get any substantive response from the Inspector General citing any authority whatsoever for the proposition that it should not be released. And what was even more rich about that suggestion was that by that point in time, the parole board had actually, the members of the parole board had actually issued and posted on their website their own response. They had gotten it. So what was he suggesting? That somehow, by releasing a copy of this report, the members of the parole board who were the subject of the investigation, who had already gotten a copy of this report, might somehow not be able to be adequately investigated. That was patently absurd. And it was sent for one reason and one reason only, and that was to shut him up, to keep him quiet, to sit on that allegation. And that is just wrong. It is corrupt and wrong. And that was the beginning. I mean, that was a year ago, and that was the very first of some of the revelations. And quite frankly, it just smells even worse with every passing day. And I can tell you, I'll tell you right now, that this investigation, like it's in this amendment, it ain't what we've been asking for. It is not what we've been asking for. Maybe it's what the chief of staff for the governor's been asking for, and there's no mystery as to why he'd be asking for that. Because it is clearly calculated to do one thing, and that is to cover up what's been going on in the office of the parole board. Now, let's see. What have we been talking about for the past couple of months? Okay, on the front page of the Richmond Times-Dispatch, there was an article about the chairman of the parole board actually instructing a member of the staff, presumably in violation of state code, to turn off the victim notification. And that was for a murderer who was convicted of raping and killing his pregnant girlfriend and then burning her body. And that email exchange that was on the front page of the Richmond paper said, you know, this might actually be a difficult, challenging case. So turn off the victim notification. All right, is this going to investigate that? Absolutely not. It is absolutely not going to investigate that. There is, more recently than that, there was another article in the Richmond paper about the parole board chair, rather stunningly, according to parole board officials and prior parole board members, and from a review of the parole board policies, allegedly improperly releasing over 100 people from active supervision without input from local parole board offices. Is that going to be investigated? How about her exchange in which somebody said, I feel drunk with power, send me more, so I can get these processed before I go off of the parole board? Is that going to be investigated? No, it is absolutely not. Is the question of whether there was an organized cover-up going to be investigated? No, that's not what this is, and it does not even allow it. Interestingly also, with respect to those 120 people who were released from active supervision, that was a pretty stunning article, and that email exchange was really shocking. And what I thought was also very interesting was the fact that the chairman of the parole board at the time is now a judge, sitting judge, and she has a lawyer. There was an article in the Richmond paper about the close relationship between that lawyer and the governor, and I applaud him for having close relationships, and that's great. But this lawyer actually said, I'm not answering any questions. That article suggested that that lawyer and who knows who else were going to be instrumental in crafting the response, trying to figure out how on earth do we control the damage here. So he said, the judge, the former chair of the parole board, she ain't going to answer any questions about releasing those 120 people unilaterally from supervised parole until after this independent investigation, which isn't even going to be allowed to look at it. So if you look at that, it leaves little question as to what the object is here. It is to divert, to conceal, to cover up, to kick this can down the road. It is a sham investigation. It is the embodiment of see no evil, hear no evil, speak no evil. And this is going to come back and bite us, okay? The parole board is releasing people in violation of laws and policies designed to keep our communities safe. Somebody is going to die at the hands of one of these people who has been released in violation of these laws and policies and procedures, and this is going to come back and bite you. I'm telling you. I hope we'll vote no.
Seeing no other senators wishing to speak on this particular amendment. The question is, shall the
Sir,
Senator,
Mr. President.
Senator from Eastern Fairfax, Senator Saravel.
If nobody else desires to speak, I would just hope the body would vote in favor of this amendment. I've been trying not to burn my second shot at the mic here, so hopefully that's it.
Thank you, Senator. Question is, shall the Senate adopt the governor's recommendation with regard to amendment number 2? All in favor of adopting the recommendation will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The Senate adopts governor's recommended amendment number 2.
Amendment number 3.
Senator? Okay. Senator from Southern Fairfax, Senator Barker.
Mr. President, I move that the governor's recommendation be agreed to. And speaking to that,
Senator, has the floor.
Mr. President, what this does is it just makes a slight adjustment relating elections. We passed provisions last year that dealt with, in the special session, that dealt with the November elections. There was legislation that was passed that will go into effect. It's already been signed by the governor, I believe, and that will go into effect July 1. What this does is provide that the same provisions would apply to elections between now and July 1, which by and large would mean that there would be some for the general elections there, and that would apply specifically, I think, to the town and city elections that may occur in May in some jurisdictions.
Do any other senators wish to be heard regarding Governor's recommended amendment number 3? Seeing none, the question is, shall the Senate adopt Governor's recommendation number 3? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The Senate adopts the governor's recommendation number 3.
Amendment 4.
Senator from Hampton, Senator Locke.
Thank you, Mr. President. I move that we agree to the governor's recommendation with regard to amendment number 4.
Senator, has the floor.
Thank you, Mr. President. The Department of Small Business and Supplier Diversity commissioned a statewide disparity study in 2020 with regard to the Governor's Executive Order 35. The study found that from 2014 to 2019, women and minority-owned businesses received 13.4% of all state contracts, yet the study found that women and minority-owned businesses would be expected to receive 32.8% of the state contracting dollars based on their availability for the associated procurement work. So what the governor's amendment does is to amend the budget to create a 5-person unit within SD to address these inequities and ensure proper implementation of the recommendations of the disparity study. So that is what the amendment does. So I move that we agree to the governor's amendment.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommended amendment number 4? Seeing none, the question is, shall the governor's recommendation number 4 be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The governor's recommendation number 4 is agreed to.
Amendment 5.
Senator from Portsmouth, Senator Lucas.
Thank you, Mr. President. Mr. President, amendment number 5 extends the Superintendent of Public Instruction's authority to grant temporary flexibility of waivers for certain deadlines and requirements as provided in Title 22.1 of the Code of Virginia and the Appropriation Act that cannot be met or must be relieved due to the impact of the state of emergency and the pandemic on our students and public schools. The state superintendent's temporary authority to grant flexibility waiver on certain deadlines and requirements expires on June 30, 2021. This amendment extends the authority through the 2021-2022 school year. This amendment does not extend any of the current waivers. Instead, it extends the authority to the state superintendent to grant waivers for flexibility measures only with the approval of the Secretary of Education. And Mr. President, the reason for doing this is that the pandemic continues to create uncertainty for our education system. Predicting how schools will need to work with and respond to their students' needs after more than 1 year of disrupted education will be a challenge. Granting authority to waive certain requirements or deadlines certainly enacted in code will allow the state superintendents the opportunity to create more flexibility within our education system to meet the needs of all students during what we know will be another unprecedented year. Flexibility in 2021-22 enables both public and private education programs to address pandemic-related needs and be responsive to the needs of families. Some waivers that have been issued during the course of the pandemic may still be needed, but others not formally included, but necessary as we work with students to address learning deficits that they so desperately need. And with that, Mr. President, I move that we agree to adopt the governor's amendment number 5.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommended amendment number 5? Seeing none, the question is, shall the governor's recommendation number 5 be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 24, noes 16.
Ayes 24, no 16. The governor's recommendation number 5 is agreed to.
Amendment 6, no, I'm sorry, Amendment 8.
Senator from Northern Fairfax, Senator Howe.
Thank you, Mr. President. I move the amendment be agreed to. And speaking to the amendment.
Senator, has the floor.
This amendment expands the use of $33.2 million of federal funds currently dedicated specifically to school-age child care and permits the funding to be used for broader purposes within the range of child care services. Among those that they are thinking about is expanding access to the mixed delivery grant program, additional support for grants and contracts to increase the supply of child care in underserved areas, expanding eligibility for and access to the child care subsidy program, and making investments in local infrastructure to support families to access high-quality care.
Senator, for what purpose is the senator from James City County, Senator Norman, rise?
Thank you, Mr. President. Would Madam Chairman yield for a friendly question?
Will Senator yield?
Yes, I yield.
Senator yields. You have the floor.
Mr. President, Madam Chairman knows that I don't work very actively in this area. Has there been a clear articulation of what these funds can be used for and what programs, or is that a work in progress?
Senator, has the floor.
Mr. President, I would respond that the administration gave me the examples, so I'm assuming that's where they're going forward.
Thank the Senator. For what purpose is the senior senator from Richmond City, Senator McClellan, rise?
Thank you, Mr. President. Speaking to the amendment.
Senator, has the floor.
Thank you, Mr. President. I ask that we adopt this amendment. One of the other examples of what this flexibility will allow is that currently these funds are dedicated specifically to school-age child care, which would be kindergarten through K through 12. However, there are many child care needs for infant care through 4, and that segment of the child care industry has been hit very hard by COVID in particular, and Virginia already had a shortage of access to that care. And so one of the things this amendment will allow is more investment of that subsidy for infant care through 4-year-olds, which is incredibly important. As we know, 90% of a child's brain development occurs between the ages of 1 and 5. So I ask that we adopt the amendment.
Thank the Senator. The question is, shall the Senate adopt the governor's recommended amendment number 8? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 33, noes 7.
Ayes 33, noes 7. The Senate adopts the governor's recommended amendment number 8.
Amendment number 12.
Senator from Alexandria, Senator Eben.
Yes, this is the appropriation of $1 million for drug recognition expert training, funded in the second year for the Department of State Police to coordinate and provide training to state and local law enforcement agencies. It'll provide training for 58 new drug recognition experts. And a DRE completes a standardized 12-step evaluation process to determine whether or not a suspect is impaired when they are suspected of driving impaired but don't have a presence of alcohol. Training DREs will not change the way DUI cases are handled, but it will better equip officers to accurately recognize individuals who are driving while under the influence of drugs. With that, I move that we accept the governor's amendment.
Thank the senator. For what purpose, the senator from James City County, Senator Norman, rise?
Mr. President, would the gentleman from Alexandria yield for a question, please?
Senator Yield?
I yield.
Senator Yields, you have the floor.
I appreciate the courtesy, sir. Knowing a little bit about this area of the law, unlike where there is a driving under the influence attributable to alcohol, there are some benchmarks statutorily that allow police officers to appropriately charge individuals for driving under the influence. There are other considerations that they use for probable cause only on the arrest, and those are generally field sobriety tests. But it's still, with a driving under the influence of alcohol, there have got to be certain statutory provisions that are met on the level of alcohol. How is this training going to instruct these officers on the appropriate level of impairment that would fall under the statutory prohibition against driving under the influence of alcohol or drugs?
Senator's floor.
This is training that officers have undergone, but not enough, and we were going to have more of them. But it's more specifically, the DRE completes a standardized 12-step evaluation process to determine, 1, whether or not the suspect is impaired, 2, whether the impairment relates to drugs or a medical condition, and if drugs, what category or combination of categories of drugs are the likely cause of the impairment. The 12-step process focuses on the observation of reliable indicators of drug impairment, which include interviewing the suspect, taking vital signs, and particularly an eye examination, and may give probable cause to conduct a blood screen test. The blood screen can detect THC or other drugs in the blood. Information collected by the DRE may be used as evidence in DUI trials as it is done today. This is certified by the International Association of Chiefs of Police and the National Highway Traffic Safety Administration. They establish the training requirements. It's the intensive training program requires a 1-day preparation course, 2 weeks of classroom training, and 3 days of certifications. It doesn't change the law, it just sees that we have officers who are able to accurately detect driving while impaired.
Thank the senator. Do any other senators wish to be heard regarding Governor's recommended amendment number 12? Seeing none, the question is, shall the Governor's recommended amendment number 12 be adopted? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 39, noes 1.
Ayes 39, noes 1. The Senate agrees to the Governor's recommendation number 12.
Amendment number 14.
Senator from Portsmouth, Senator Lucas.
Thank you, Mr. President. Mr. President, I move that the Senate adopt governor's recommendations on amendment number 14.
Senator's the floor.
Thank you, Mr. President. Mr. President, budget amendment number 14, the amendment relates to House Bill 2312 and Senate Bill 1406, which legalizes simple possession of marijuana and establishes a regulatory framework for marijuana sales. The governor's budget amendments provide $1 million in fiscal year 22 for the marijuana prevention and education program, including a public awareness campaign. The funding supports health campaigns and prevention strategies to educate the public about the health and safety risks of marijuana. It's important that legalization be associated with clear messaging to the public about potential negative health effects associated with marijuana use. The funding will include programs targeted to youth and college-age populations who are more at risk, especially vulnerable to the negative effects of marijuana. The Department of Planning and Budget will direct the $1 million in general funds to be appropriated to the appropriate state agency. And with that, Mr. President, I renew my motion to have the Senate adopt the governor's recommendations on amendment number 14.
Thank the senator. Do any other senators wish to be heard regarding Governor's recommendation on amendment number 14. Seeing none, the question is, shall the governor's recommendation on amendment number 14 be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 38, noes 2.
Ayes 38, noes 2. The Senate adopts governor's recommendation with regard to amendment number 14.
Amendment number 18.
Senator from Fairfax City, Senator Peterson.
Mr. President, speak to the amendment.
Senator's the floor.
Mr. President, ladies and gentlemen of the Senate, this has to do with a bill that we passed last summer which made federal relief payments exempt from garnishment, but it limited them to, I believe it was $1,200. And this takes off that limit mainly because the next round of relief payments were over $1,200. Now, one of the reasons I put that limit on there was I was concerned about PPP money and whether or not that would be exempt from garnishment, even if the money was duly owed to creditors. And I've had conversations with bankers and the lenders, and basically the bottom line is that money is not considered a relief payment, but rather a loan that's then forgiven. So therefore, it would fall outside of the scope of this. So the bottom line is, now that the relief payments have basically gone over $1,200, it's simply easier for our lenders and banks to simply go ahead and take off that $1,200 cap. It really no longer applies. So I'd ask that we agree to this amendment.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommended amendment number 18? Seeing none, the question is, shall the Senate adopt governor's recommended amendment number 18? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 38, noes 2.
Ayes 38, noes 2. The Senate adopts governor's recommended amendment number 18.
House Bill 1855.
Mr. President.
From Fairfax City, Senator Peterson.
Mr. President, I get two in a row. I would move that we adopt the governor's amendment and speak in support.
Senator's the floor.
Mr. President, House Bill 1855 had to do with renaming the DMME, the Department of Mine, Minerals, and Energy, to the Department of Energy. I guess we'll just call it the DE. Basically, there was a drafting error in there that somehow slipped past us in committee. And so there needs to be an amendment to subsection C of 56-596.2. That was inadvertently left out of the legislation, and I guess we need to change the name there also. So this is technical in nature, and I hope we all agree to it. Thank you.
Thank the senator. Do any other senators wish to be heard? The governor's recommendation with regard to House Bill 1855. Seeing none, question is, shall the governor's recommendation with regard to House Bill 1855 be agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 25, noes 15.
Ayes 25, noes 15. The Senate agrees to the governor's recommended amendment with regard to House Bill 1855.
House Bill 1890.
Senator from Bath, Senator Deeds.
Mr. President, I move adoption of the governor's recommendation.
Senator's the floor.
This recommendation is fairly technical and was recommended by the Division of Legislative Services. It's my understanding it's identical to a recommendation that we agreed to earlier today to a bill from the senior senator for the city of Richmond. That was Senate Bill 1395.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommendation? Seeing none, the Question is, shall the Senate adopt the governor's recommendation with regard to House Bill 1890? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The Senate adopts the governor's recommendation with regard to House Bill 1890.
House Bill 1899, the House did not adopt. House Bill 1936.
Senator from Roanoke City, Senator Edwards.
Mr. President, I move that the Senate adopt the governor's recommendations.
Senator's the floor.
What this recommendation does, Mr. President, this is a bill that divides robbery into several categories. And what the amendment is to make it clear that the third category of robbery, when it comes to juveniles, that the juveniles would remain in the juvenile system. Currently, the statute does not distinguish between the different categories of robbery, and the Commonwealth Attorney has discretion to transfer a juvenile age 16 and older to the circuit court to be tried as an adult. But these Class 2 and Class 3 felonies would remain transferable. But the other category, the lowest category, Class 5 category, allows for the juvenile. The juvenile would remain in the circuit court, in the juvenile court, and would not be transferable to the circuit court. So, with that recommendation, I move that the governor's recommendation be adopted.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommendation? Seeing none, the question is, shall the Senate adopt the governor's recommendation with regard to House Bill 1936? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The Senate adopts the governor's recommendation with regard to House Bill 1936.
House Bill 1962.
Senator from Arlington, Senator Favola.
Thank you, Mr. President. Mr. President, I move that the governor's recommendation be agreed to. And speaking to that motion.
Senator, is the floor.
Thank you, Mr. President. What the governor's recommendation does is it ensures that when the foster care worker prepares a plan for foster youth, that victim kin be included, and that we also include this language in our state the kin gap program. The current bill only included the federal kin gap program. The governor has added the language to our state program. This is a program that diverts our youth from foster care and tries to place them with relatives, and I strongly recommend that the body adopt the governor's recommendation. Thank you.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommendation? Seeing none, the question is, shall the Senate adopt the governor's recommendation regarding House Bill 1962? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The Senate adopts the governor's recommendation with regard to House Bill 1962.
House Bill 1992.
Senator from Roanoke City, Senator Edwards.
Mr. President, I yield to the senator from Arlington to explain it.
Senator from Arlington, Senator Favola.
Thank you, Mr. President. Mr. President, I would like the Senate to rule that these line amendments are in fact specific and severable. I would like to address lines 1 and 2 together and line 3 separately, but I think we'd have to. Fair enough. Mr. President? Okay.
Okay.
Would you like to advise me on a parliamentary procedure?
Yeah, no, I think this will be a little simpler to do it this way. We have 3 amendments here with regard to House Bill 1992, and the senator is free to move them in whichever order you'd like. So if you want to move just Amendment 1 first, or 1 and 2, and then 3, you can do it that way. So you don't have to have a specific separate motion to do that. I would just, you would move Amendment 1 or 2 and do it that way.
Point of parliamentary inquiry. I may move 1 and 2 together because 1 is sort of just a.
Yes, exactly. That's totally fine if you want to do it that way.
Thank you, Mr. President. I'm glad you gave me the advice. Okay, ladies and gentlemen, I move the governor's that we agree to the governor's recommendation on line item 1 and 2. What that does is it expands the definition of household member to actually include an individual who cohabits or who was with the individual family member for a previous 12 months, and any child of either of them residing in the home. And I just want to note this is a little different than what the bill was that we had passed, but the intent of the governor's recommendation is there are a fair number of couples who are cohabitating, not married, and domestic violence, in fact, does take place in those situations. And you should also know that a third of our homicides are really the result of domestic violence, and more than a third of our suicides. So this is a public health issue. It is an issue that is intended to protect our women and children. The underlying bill, if some of you might recall, was a bill that dealt with a loss of a firearm if there was a misdemeanor assault and battery conviction. So we had a definition of household member. The governor has recommended a slight expansion, and I would hope it would be the will of the body to adopt this recommendation.
Thank the senator. For what purpose, Senator from Fairfax City, Senator Peterson rise?
Mr. President, speak against the motion.
Senator's floor.
Mr. President, ladies and gentlemen of the Senate, we spent a lot of time on this in the regular session. I know we have 1 new member, so I'll do a little bit of an update. This had to do with legislation which my colleague from Arlington carried, and we defeated in the Senate, which would have basically taken any domestic violence conviction and then taken away gun rights for, I believe it was a number of, it may have been permanently, although with a potential right of restoration. When that bill came over from the House, I paid special attention to it, and I wrote this language very specifically. And I made sure that it only related to that domestic violence which arose from, frankly, a romantic relationship. I was very careful to not include that situation where you might have siblings or roommates or anybody else who would, quote, cohabitate, even with children, and might get into an altercation which would then fall into a domestic assault, because, quite frankly, that was not the purpose of the legislation. And I'll be honest, I've been in this business about 20 years, and when you give your word to somebody, I expect you to keep that word. And I did not expect this amendment to come back, and frankly, it should not have come back. And that's a lesson learned from me, because otherwise this bill would not have passed this body. So I will simply say this bill expands the definition in a way that we did not intend. Frankly, the way you could interpret this, it has nothing to do with having a romantic relationship. You could have a roommate. You could be living with your sister. You could be living with, a couple people in the same house that are unrelated. And if there's a child there, which is a child of either one of them, and they get into an altercation, a shoving match, there's police are called. Now somebody loses their gun rights for 3 years. And I realize that having gun rights is not important to some people, and I get that. But it's important to other people. And again, we were very careful in how we drew this language. And I was very disappointed the governor's office would send down this amendment without any consultation to those of us that reached that agreement. And frankly, Again, you got to have your integrity in this business, and I was disappointed to see that. I ask that we oppose this amendment.
Thank the senator. For what purpose is the junior senator from Richmond City, Senator Morrissey, rise? Thank you, Mike.
Thank you, Mr. President. Speaking to the amendment.
Senators, the floor.
First, I'd like to identify myself with the comments by the senator from Fairfax City, but this actually goes beyond that. Not only do we have a robust discussion regarding the permutations of family members, but this bill, this amendment now says if they cohabitated within the last 12 months, they don't even have to be living together now. 11 months previously, they could have signed a lease, been roommates, moved out, and then two women who were roommates get a dust-up, a shoving match, as the senator from Fairfax City said, and now they are prohibited from having a gun from increases from 3 to 5 years. This goes well beyond what we agreed, and for those reasons, I'd ask that the body reject the governor's amendment.
Thank the senator. For what purpose is Senator from Arlington, Senator Favola, rise?
Well, Mr. President, I just want to make one concluding remark. Again, this conversation is about the removal of a firearm from an individual who has been convicted of assault and battery. It does not change the application of our assault and battery law. It merely is intended to stop a violent escalation so women and children can be protected in their own home. I do not understand the anxiety over this, but I respect the views of my colleagues. But again, I'm asking that we take a vote to protect our women and children. I hope it is the will of the body to adopt the governor's amendment. Thank you.
Thank the senator. The question is, shall the Senate adopt the governor's recommended amendments numbers 1 and 2? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 12, noes 28.
Ayes 12, noes 28. The Senate does not adopt the governor's recommended amendments number 1 and 2.
Amendment number 3.
Senator from Arlington, Senator Favola.
Thank you, Mr. President. Mr. President, I move that we adopt the governor's recommendation on item number 3. Which item?
The floor.
Thank you, Mr. President. Item number 3 extends the 3-year period to 5 years by which a person who, again, is convicted of a misdemeanor assault and battery can have an automatic restoration of a firearm right. The current bill is at 3 years. The governor has amended it to 5 years. That's his amendment. And the rationale is there's a parallel in our code, which apparently if you have been convicted of a drug offense within a 36-month period, you would lose the firearm for 5 years. So the governor has felt that we should parallel that statutory language and move our 3 years to 5 years. Again, it would be an automatic restoration, and we're trying to break the cycle because experts are telling us that violence always escalates. So taking a break from owning a firearm is not a bad thing. I would ask that we support the governor's amendment. Thank you, Mr. President.
Thank you, Senator. For what purpose, Senator from Fairfax City, Senator Peterson, rise.
Thank you, Mr. President. And again, with love and deference and affection to my colleague, I'm going to oppose this amendment also.
Senators, the floor.
I won't reiterate the comments I made about the process we went through, but the 3 years was chosen intentionally. Quite frankly, I wanted to make it 24 months because that would be the period of time that you would serve, and then probation from the misdemeanor, and then any anger management classes you would have to take, and then I sort of round that up, and I had 24 months, and I decided to make it 3 years just to be on the cautious side. Frankly, if anything, I felt like that was pretty aggressive. Moving it to 5 years, I think, is very aggressive. And one thing I didn't mention in my last comment, but we've talked so much about criminal justice reform. And then we passed bills dealing with firearms that suddenly exposed people to being convicted of crimes, as if somehow it's a totally separate conversation. People own firearms. people in the city, people in the country, people in the suburb, they own firearms, and if we put them in a position where they're going to be, for a number of years, supposed to not have that firearm, we're going to put them in a position to reoffend. So, again, I think the 3 years was chosen intentionally. I felt it was pretty aggressive at the time. And again, I was disappointed to see this amendment because that was not the deal we made back in February. So I asked that we oppose this bill, or amendment, please.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommended amendment number 3? Seeing none, the question is, shall the Senate adopt governor's recommended amendment number 3? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 14, noes 26.
Ayes 14, noes 26. The Senate does not adopt governor's recommended amendment number 3.
House Bill 1999.
Senator from Northern Fairfax, Senator Howe.
I move that we adopt the governor's amendments, and speaking to that.
Senator, the floor.
Our approach in the budget was to authorize the tax commissioner to waive interest on any class of taxpayers when he finds that imposing interest has caused or would cause undue hardship because of a natural disaster or any other reason. And the waiver of interest is permitted only to the extent that the governor has declared a state of emergency. What the governor is now proposing is to add the word emergency to the title and add an emergency clause. These are significant because the emergency clause will enable the tax commissioner to waive interest on tax payments made under the individual income tax filing and payment deadline that was extended from May 1st of this year to May 17th of this year. Under current law, the tax commissioner is explicitly authorized to waive penalties and grant extensions, but he does not have the authority to waive interest. So I again move that it be agreed to.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommendation on House Bill 1999? Seeing none, the question is, shall the Senate adopt the governor's recommendation with regard to House Bill 1999? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? Clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The Senate adopts the governor's recommendation with regard to House Bill 1999.
House Bill 2031.
Mr. President.
Senator from Hanover, Senator McDougal.
Thank you, Mr. President. I move that the governor's amendments be agreed to. And speaking to the motion.
Senator, the floor.
Mr. President, when this bill came over from the House, we put on a substantial amendment that would require, among other things, search warrants in order for law enforcement to access biometric information, which is facial recognition in this case. The way the bill came over from the House, though, there was an exception granted for commercial service airports. Unfortunately, that exception was drafted in the campus police section. So this amendment just takes it out of the campus police section and puts it where it needs to be.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommendation? Seeing none, the question is, shall the Senate adopt the governor's recommendation with regard to House Bill 2031? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The Senate adopts the governor's recommendation.
House Bill 2038.
Senator from Roanoke City, Senator Edwards.
Mr. President, I move that we adopt the governor's recommendations.
Senator, the floor.
And by way of explanation, this is a bill dealing with technical violations of probation. And it clarifies the term imposed. It allows a court to toll the period of probation or suspended sentence for a person who has absconds, and ensures the defendant is still subject to compliance review hearings if they owe restitution, and allows an extension of the period of the suspended sentence to allow the defendant to complete a court-ordered program. These are technical violations, and I move that the governor's recommendations be adopted.
Senator, do any other senators wish to be heard regarding the governor's recommendation? Seeing none, the question is, shall the Senate adopt the governor's recommendation regarding House Bill 2038? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The Senate adopts the governor's recommendation.
House Bill 2040.
Senior Senator from Fairfax, Senator Saslaw.
Yes, Mr. President, members of the Senate, this was a bill that required the Virginia Employment Commission, VEC, to waive obligation of repayment on, if the overpayment was made without default on the part of the claimant, and requiring repayment would be contrary to equity and good conscience. In other words, they just flat had no way of doing this. And that's the bill applies to overpayments established for the week commencing March 15, 2020 through June 26, 2021, and only to those overpayments that remained outstanding as of 2021. Now, there's two amendments. The first amendment is a simple one. It changes June 26th to June 27th of this year because the VEC week begins on Sunday, not on Saturday. So that's the first change, just a date change. The second change removes, it says in the bill, it said as of July 1st, 2021, and because an overpayment could occur between the week of March 15th of 2020 and June 27th of this year, and not be determined by the VEC to be an overpayment until after July 1st of this year. And removing the language will allow VEC to waive the obligation to repay the overpayment that occurred in the period but aren't determined to be overpayments until later on after July 1st. So that's what the two changes essentially have done. Have clarified some of the dates in the bill. And I would ask that you accept the governor's amendments.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommendation on amendments? Seeing none, the question is, shall the Senate adopt the governor's recommendations on amendments with regard to House Bill 2048? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The Senate adopts the governor's recommendation with regard to House Bill 2040.
House Bill 2047.
The senior senator from Richmond City, Senator McClellan.
Thank you, Mr. President. This is the House version of Senate Bill 1315, the bill that allowed criminal defendants to present evidence of mental health conditions. These amendments are identical to the ones that we adopted earlier today, and I move the governor's recommendations.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommendation on House Bill 2047? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 24, noes 16.
Ayes 24, no 16. The Senate adopts the governor's recommendation.
House House Bill 2055.
Senator from Eastern Fairfax, Senator Servo.
Thank you, Mr. President. I move the governor's recommendation and speaking to that motion.
Senator's the floor.
Thank you, Mr. President. Ladies and gentlemen of the Senate, you might remember this bill. It has to do with when a court can impute income to somebody who's incarcerated for a reason other than non-payment of child support or domestic abuse of their spouse or child. We made an amendment, an enactment clause amendment to this bill in this body to make clear that the passage of this statute did not provide a basis alone by which somebody could modify child support. The DSS contends that this would put us in violation of federal requirements. I disagree with them, along with every other lawyer who serves on the child support work group with me. And in light of the fact that nobody can agree what federal rules require and what they do not require, the governor has put this reenactment clause on the bill to give us another 12 months to figure it out. The regulations that require this change do not require us to make this change until next session. So there's no urgency or jeopardy leaving us out of compliance for the next 12 months. And so this just sort of kicks the can to next session when we can keep on having a discussion about the interplay of child support in the United States Constitution. And so I'd ask the body to adopt the amendment so we can keep talking about this.
Thank you. Senator, do any other senators wish to be heard regarding the governor's recommendation on House Bill 2055? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 36, noes 4.
Ayes 36, noes 4. The Senate adopts the governor's recommendation.
House Bill 2113.
Senator from Eastern Fairfax, Senator Servo.
Move the governor's amendments and speaking to that motion.
Senator's the floor.
Thank you, Mr. President. I guess I get to go back to back. This is the cognate of Senate Bill 1339, which we all approved the amendments to around 2 p.m. today. If everybody remembers what they are, I don't need to explain them again, but I hope we would take the same action we did earlier today.
Thank the Senator. Do any other senators wish to be heard regarding the governor's recommendation on House Bill 2113? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 23, noes 17.
Ayes 23, no 17. The Senate adopts the governor's recommendation.
House Bill 2133.
Senator from Roanoke City, Senator Edwards.
Mr. President, I move that we adopt the governor's recommendation.
Senator's the floor.
Mr. President, what this does, Senate House Bill 2133 establishes the procedures for victims of sex trafficking to have their records related to the offenses vacated and the police and court records expunged for such convictions. What the governor has done is amended the legislation to make the definition of victims of sex trafficking consistent with the prior bill that we passed, and the governor's already signed House Bill 2234. So that's all it does. It makes the definitions the same to avoid unintended consequences. With that explanation, I renew my motion that we adopt the governor's recommendation.
Thank the Senator. Do any other senators wish to be heard regarding the governor's recommendation on House Bill 2133? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The Senate adopts the governor's recommendation.
House Bill 2138.
Senator from Western Fairfax, Senator Marsden.
Thank you, Mr. President. I move that the governor's recommendation be agreed to. And speaking to that,
Senator's the floor.
Thank you, Mr. President. The underlying bill deals with the confidentiality of ID cards issued by the Department of Motor Vehicles. And at that time, they anticipated that there was only one kind of ID card. In fact, there are several. And so the language merely reflects the fact that there are multiple cards. And I renew my motion that the governor's recommendation be agreed to.
Thanks. Senator, do any other senators wish to be heard regarding the governor's recommendation on House Bill 2138? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The Senate adopts the governor's recommendation.
House Bill 2167.
Senator from Arlington, Senator Favola.
Thank you, Mr. President. Mr. President, I move that the governor's recommendation be agreed to, and speaking to that motion.
Senator's the floor.
Thank you, Mr. President. What the governor's amendment does is it moves up the date by which the parole board must publish its monthly reports on the website. Some of you may recall that we looked at several bills this past session dealing with the parole board and the type of information that would be included in the monthly report regarding the parole board's decision. And we wanted to get that information published on the website sooner rather than later. During session, we were told that we needed a delayed enactment until July 1, 2022. The senator from Rockingham specifically said on the floor that we should move towards a December 2021 deadline, and the governor has accommodated that, and that is his recommendation. So I do hope it is the pleasure of the body to adopt this recommendation. Thank you, Mr. President.
Thank the senator. For what purpose is Senator from Rockingham, Senator Obenshain rise?
Mr. President, speaking of the amendment, not
Here's
to
the floor.
sound ungrateful, but this is a very slight measure of relief from this governor. I hope it makes him feel like he can tell people he's doing something before he leaves office concerning this parole board scandal. In fact, we asked him to implement this on July 1. And when we were here before, back during the special session, they said, well, whatever, that'll be fine, no problem. And as a matter of fact, they never sought to change that. But when we came back in session, they said, can't possibly do it by July 1. So I do appreciate the governor's concession that he will have that go into effect at the end of December of this year, in time for the first report to come out after the next governor takes office.
For what purpose, Senator from Arlington, Senator Favola rise?
Mr. President, I just renew my motion. We're making progress. I know it is not as fast as the senator from Rockingham would like, but this amendment is worthy of a vote. Yes. Thank you, Mr. President.
Thank the senator. Question is, shall the Senate adopt the governor's recommendation with regard to House Bill 2167? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 37, noes 3.
Ayes 37, noes 3. The Senate adopts the governor's recommendation.
House Bill 2168.
Senator from Roanoke City, Senator Edwards.
Mr. President, I'll be happy to yield to the senator from Northern Fairfax in the town of R.E. Simon Tunn. Preston.
Thank the senator. Senator from Northern Fairfax, Senator Howe.
Thank you, Mr. President. This is the amendment that makes certain that gray machines will not slip back into our state.
Thank the senator. For what purpose, Senator from Franklin County, Senator Stanley rise?
Thank you, Mr. President. Speak to the amendment.
Senator's the floor.
Thank you, Mr. President. I want to be clear, and I think I've been clear since the very beginning, that when it comes to gambling in the Commonwealth of Virginia and legalizing gambling, I've never been for it. I see a lot of problems that are created by gambling. I think gambling presents itself as a panacea, that a false Trojan horse to rural areas, to once industrialized areas, as getting themselves out of the current economic predicament that they're in. I voted against gambling bills, with the exception of saying that if you're going to tax the gambling, then the revenue should go to the modernization of schools. But the majority here legalized it, but not all of it. Some of it, but not all of it, which I think is patently unfair. Because if you're going to legalize gambling, why would you take out skills games? Well, I think I have an answer why. Because we picked winners and losers. Winners were big casinos. Those big casinos hired 53 lobbyists, gave over $1 million, spread around both parties. Skills games in small businesses. Small businesses in rural areas and urban areas. Didn't have the lobbying force of 53 lobbyists. Didn't have the money behind it. But we've decided for ourselves that big casinos where you can afford to go to a casino if you're upper middle class is classy. Skills games somehow are oogie. That's right, I used the word oogie on the floor today. We've decided that that's low-class gambling. Even though during the pandemic, ladies and gentlemen, I would remind you that it was this low-class gambling that generated $150 million to help in the pandemic relief. We let it go till July, but now it's not good enough. You know why it's not good enough? Because the casinos say it's not good enough. The big out-of-state casinos run by, if you look at the board of directors, Lily White, who are hurting actually the small businesses, the convenience stores, the restaurants owned by Asian Americans, Indian Americans, African Americans. Yes, for real. And so why are we picking winners and losers with outside businesses, outside major, big, giant, big casino corporations, but forgetting about the little guy that helped us through the pandemic when we deemed them to be essential, sometimes the singular food source or gasoline source for many of our people who suffered through the pandemic. We certainly took the $150 million willingly, but nope, we're right back to skills games are bad. And I remind you, I'm not for any kind of casino gambling, but if we're going to do it, let's do it fairly. And let's not leave out the small business owner, the small convenience store owner who crosses the spectrum of our citizenry. Why are we doing that? Because big casino, where the house always wins and the little guy always loses. Where's big casino? Where's that $150 million? Oh, it's up. That's right. It's not coming in for another 3 or 4 years, if at all. So let's harm the little guy. The guy that was there, the man and woman that was there, running their store for you, generating that tax income. I've gotten calls from those people. Those big businesses, those casinos, that's what the governor cares about. Doesn't care about those small businesses. But those business owners are calling, saying, why are we being left out? In fact, some of those business owners came up with a really good idea. They said, let's take that $150 million. They went to the governor with this idea. They said, let's take that $150 million in tax revenue that we generate, and then we take that money, and we'll be able to pay for the full ride college education, 4-year at a state-supported institution, room, board, tuition, the whole schmear, for 10,000 children that are living at or below the poverty level throughout the Commonwealth of Virginia. This was taken to our governor by those small businesses that wanted to keep skills games in their establishments. And guess what the governor's office said? Nope. No, I don't care about those 10,000 children living out or below the poverty level who could get a free 4-year ride, 4-year education in a state-supported school. I care about big casinos. Shame. 10,000 children that could break the cycle of poverty. No, big casinos mattered more. What are we doing? Why are we passing up this opportunity to break the cycle of poverty for so many young men and women? Because have we sold out to big casino? Have we chosen big casino over small business? Because if we have, then hypocrisy has a name. And we're looking at it. You should, I was on the conference committee in this report. It was not intended to promote skills games, but now that we're having that discussion, I think what we're doing right here in picking winners and losers just demonstrates that those skills games aren't oogie. We're oogie. We sold out the big casino. Should never have done that. And we sold out the men and women of these small convenience stores. And we sold out those 10,000 children that could have had a free 4-ride education at the University of Virginia, all paid for. We sold it out for big casino. I ask that you reject the governor's amendment on House Bill 2168. Shame on us all.
Mr. President.
For purpose, Senator from Williamsburg, Senator Mason rise.
Gentleman from Franklin, yield for a question.
Will Senator yield?
I'll yield. I haven't talked to money all day.
Senator yields. You have the floor.
I've been quiet until that soliloquy, Mr. President. Mr. President, I have a question. I asked the gentleman that coming out of the conference committee, was it your understanding that we were extending skill games for another year based on the agreements made during conference?
Senator's the floor.
Mr. President, I'd answer the gentleman by saying no, not really at all. No. I actually learned about this. I think I read in one of our online newspapers that this was interpreted as being what it would have the operative effect of doing. But since this was being up as it was as an amendment described as killing skills games, I thought it necessary to take the opportunity to really let you know how I felt, which I'm not afraid of doing around here.
Mr. President, gentleman, yield for another question.
Senator yield.
Of course. I love talking to
Senator yield. You have the floor.
Thank you, Mr. President. Since the gentleman referenced this G3 is great, wonderful scholarship that I think we've all seen a flyer for, that ends, and they won't be the only winners because skill games revenue is the difference between hope and failure during the pandemic for the owners of the thousands of family small-run businesses. Since that matches up so well with the gentleman's speech, could he inform the body as to who produced that flyer, who's behind it, and where they came up with that information?
Senator's the floor.
Mr. President, I do not know of any flyer that he speaks of, so I can't answer that question. I don't know anything. But, G3 attempts to do something, but it financially is insignificant or inadequate. But again, we're talking about community college. What the opportunity was presented to the governor was to take that tax money and pay for a 4-year education, 4-year, full ride, even expenses paid for, which are not covered by G3, for children living at or below the poverty level. Think about every 4 years we could get 10,000 children outside of poverty with a college degree. I mean, that's educating right out of poverty. That's smashing the cycle of poverty, and that's what I'm all about. So I didn't see a flyer, so I can't answer that. I don't know what you're talking about. Seriously, I don't read my mail in the boxes sometimes. So it might have been stuck in there, and I haven't been over to the Pocahontas building in a while. So I don't know that you have, but,
Fascinating. Thank you, Mr. President. I thank the gentleman.
Thank the senator. For what purpose is the junior senator from Richmond City, Senator Morrissey, rise?
Thank you, Mr. President. Mr. President, I want the body maybe just to tap the brakes for a moment and I want to, I think, explain why I'm going to put up a no vote for this, and I hope that you will too. Here's why. With great deference to the gentleman from Franklin County, I don't attribute any malevolent or evil motives to the governor at all. I don't believe he doesn't care about 10,000 children at all. Here's why I'm asking you to vote no. This bill discriminates against small businesses. In my Senate district, there is a large Asian community, Indian community, Pakistani, Yemeni community, and African Americans that have small businesses in every corner. Now, when you leave here, you often will go down Broad Street, get on 95 or 64 to other parts of Virginia. But if you ever have an opportunity to go through Churchill or Petersburg or Hopewell, you'll find most of these small businesses are corner stores. And they eke out a living, and they've made a living by having 2 or 3 skilled machines in there. And the gentleman from Franklin is correct that it is the large businesses, the casinos, that have seemed to gather all the luster. And I find it ironic that we want to end these skilled games in small businesses, but it's okay for the large casinos. And what is interesting is that these large casinos are operated by rich, wealthy, white, out of Commonwealth citizens. Take Caesars. There's a casino going into Danville. Caesars is from Las Vegas. The Rush Street Gaming Organization that is going to put up the casino in Portsmouth is from Chicago. The Hard Rock one that is going to put it in Bristol is from California. We haven't decided in Richmond yet. So there has been a cadre of lobbyists that have come in and said, casinos good, let's go for that. But who's lobbying for the smaller businessmen? Not as many. And these smaller businessmen, the ones that are running these corner groceries, have these skill machines. Now, the senator from Franklin referred to $150 million. That's the money that the skill games are generating that were available to the Commonwealth for pandemic relief. But what was proposed to the governor was that this $150 million would not just go to 10,000 students, but every poor Virginian in the Commonwealth who could not afford a tertiary education will get this 4-year education. It would be known as the Yvonne Miller Ben Chafin Scholarship Fund. And so what I find just preciously ironic about this is that we are absolutely fine with the big casinos going in, but not so much for the small guy. It's okay to have maybe in the future, the small pot shop. Maybe we can put that next to the small payday loan or title loan shop. And you know where it's going. It isn't going into Western Henrico. It's not going into certain wealthier sections. But give these small businesses a break. They have 2 to 3 machines in there. They eke out a living. If you want to decry skill machines as sinful, then so are their casinos, although I don't think either one of them are sinful. It's just a choice. Take a moment before you leave the Capitol and visit Churchill. Stop by almost any street corner. You'll go in there, you'll find a fabulous, very professional Pakistani or member of the Yemeni community or African-American businessman that will greet you. Buy your bottle of pop, your candy bar, and you'll see a couple machines there. Let them continue to do that. The state will benefit to the tune of between $150 and $200 million. The big guys are going to be fine. The big casinos will be fine. And by the way, I've got some skin in the game. Rosie's, that's in my district. And I've told those folks over there, don't worry about the little people. You guys are still going to be fine. But let's watch out for the little guy. Let's give them a break. So for those reasons, I'm asking you to put the brakes on and put up a red vote on this amendment. Thank you.
Senator, for what purpose is Senator from James City County, Senator Norman rise?
Thank you, Mr. President. I rise to speak in favor of the governor's amendments.
Senator, is the floor.
Mr. President, I refer to this bill as the anti-Alibaba bill on it for a number of reasons. First of all, it's important to remember that when these, quote, games of skill started in Virginia, they were completely unregulated, and they propagated themselves that would have embarrassed all of the Easter bunnies because they were going across the state unregulated faster than anyone could track them. Secondly, it is embarrassing to say they're games of skill. There is no skill in this. It's all the probabilities, just like any other machine on it. I would say, Mr. President, further, that this piece of legislation and the amendment was not advocated as strongly by casinos as it was by the chairman of Senate Finance and myself. And in fact, when the administration started equivocating just a little bit because they were salivating at the prospect of getting more money to distribute as they would like, and not just to Southside, I would say, that Madam Chairman of Finance and myself reminded the administration that this was not so much a matter of finances, but a matter of personal integrity, because that is the assurance that we had been given, or we would have taken care of it later on. It was interesting to me that in another bill from the House of Delegates, mysteriously there was some subtle language that was put in there that no one really discussed during the course of the legislative process, but when it was being reviewed by the administration, all of a sudden there was a previously uninterpretation that was interpreted that it allowed it. And the Senate Chairman of Finance and myself spoke out. So I would say, Mr. President, I understand the passion, understand the little guys, but I think it's important to understand where this came from, and we need to adopt this amendment.
Thank the senator. For what purpose does the senior senator from Chesapeake, Senator Cosgrove, rise?
Speak to the recommendation.
Senator's floor.
Thank you, Mr. President, ladies and gentlemen of the Senate. Skill machines, gray machines. Folks, these are the scooters of the gambling world. They show up, they're unregulated, they put them wherever the heck they want to. They don't contact the state, they don't contact localities, but then they go, oh, look how wonderful we are. Well, I brought this up 3 or 4 years ago when we first started seeing these, and I told you then, and I'll remind you, you're going to see thousands of these things, thousands of them throughout the Commonwealth, and the Commonwealth's not getting a cent out of them, and they didn't for the first couple of years. Now, this has nothing to do with big casinos. I never really thought I'd hear the gentleman from Franklin County have taste for the children, but that's what we heard. Yeah. And we talk about who owns the big casinos. Well, who do you think owns the skill machines, the gray machines, the previous illegal machines? Now, I will tell you, there was a solid agreement last year that these would be taken away at this time. I appreciate the chairman of Finance and Appropriations sticking to her guns on that. And I hope, ladies and gentlemen, that we will look at this and follow through on the promises that were made last year. These things should not be in the Commonwealth the way they are. They deserve to go. Thank you.
Thank the senator. For what purpose, Senator from Prince William County, Senator McPike, rise?
Speak to the amendment.
Senator's the floor.
Thank you, Mr. President. I hope that the body adopts this amendment, and I'm a little dumbfounded that we didn't have such impassioned speeches from our conferees when the conference report was being presented. Just amazing, like a blind pig finding an acorn all of a sudden, and now it's a golden gem, specifically with talking points from some reason from the industry. I wanted to say thank you to Senator Cosgrove. He's absolutely right. 4 years ago, he came to committee and said, we got a problem. And I was skeptical. I said, what's going on? And I didn't believe him. So, John, I apologize to you. I thank the senator from James City County and as well as the chair of finance for holding true. I voted against the budget amendment last year. And this predates casinos, just to set the record straight. As Senator Cosgrove had pointed out, this has been going on for years. And we have not wrestled it. This is finally going to put this to bed. This is unregulated. It's been that way for years, up until this past year. It's been, frankly, a despicable business behavior and the tactics that have been used in committees and against this General Assembly and many other. I think we it's long time to put this to bed. Thank you.
For what purpose does the senator from Western Fairfax, Senator Marsden, rise?
Thank you, Mr. President. Speak to the bill.
Senator's the floor.
I could preach this any number of ways. There are good points made all around. But the thing for me is that I think you have to look at who was asking for these casinos. Senator Carrico, when he was here, he was against gambling, drinking, dancing, everything. But when it was time to revive the economy of Bristol, he yielded to the reality of we needed something different. And same thing for Portsmouth and other places. These casinos will create jobs. They will help rebuild the economies of the future. And when all this federal money washes through our system, we are going to have a troubled future. We got difficulties coming. And the thing I have a problem with the gray machines is that the very businesses that, the very people that use them are those who can least afford to do it. At least with a casino, you got to get in a car. You got to have more than $5, and you're going to spend money that perhaps, in most cases, you may be able to afford. But to see people just throw their lives away, to be honest with you, in the lottery or in these gray machines, it just breaks your heart. So, reluctantly, I would ask that we agree to the governor's amendment.
What purpose does the senator from Loudoun County, Senator Bell, rise?
Speaking to the amendment.
Senator's the floor.
Mr. President, I align myself with those who support the governor's amendment. And I wasn't planning on speaking on this, but I just want to say a few things. We've looked at gray machines, and if you look at the history, this is a troubled area. In Georgia, once that automatic reporting happened when they had these, the revenue doubled the next month. Doubled the next month. If you look at the agreements these convenience stores have signed to get gray machines, they're very onerous. They have a lot of non-competes. Frankly, unfortunately, I think they've been taken advantage of. I put in a bill this past session, it wasn't successful, to put VGTs in place of them. Now, the casinos really oppose that. But I'll tell you, I'm not opposed to having machines there, but I'm opposed to having these gray machines there because they have a problematic history. And frankly, there's a lot of research that shows that there's really not a game of skill, particularly not if people have had alcohol or have had any other distractions while they're playing them. I think we need to take a good hard look. If we also look at the states who've had gray machines, the proliferation of these machines is out of control. In a very short period of time, they didn't have 5,000, 10,000. Once they did a real accurate count, they had 30,000, 40,000 machines. This could be a huge problem for us. And frankly, I think there's many more machines out there now than we even know about. So the gray machines, my heart goes out to the convenience store operators. I think there's other ways we can make them whole. Gray machines is not the way. Thank you, Mr. President.
Thank the senator. What purpose, senator from Northern Fairfax, Senator Howe, rise?
I'd like to expand on my comments, Mr. President.
Senator's the floor.
First of all, I want to totally agree with everything that the minority leader said. We have been working together on this from the beginning. We have had commitments, and we believed, or at least I believed, everybody would be forthright and honest on this whole procedure. Unfortunately, I was wrong. The industry, which had indicated they would be satisfied with 1 year, has come back. They have hired, you should look it up, multiple lobbyists, multiple lobbying firms here in Virginia. And they have put forward this idea, which I hope none of you believe, that the proceeds would go to funding education for our low-income students. That is a fabrication that some of these lobbyists have made and put out, and it has no reality and no basis in reality. So I would, again, urge that we support the governor's amendment. It is him living up to his commitment to us, and I think we should likewise live up to our commitment to him. Thank you, Mr. President.
Thank the senator. Question is, shall the Senate adopt the governor's recommendation with regard to House Bill 2168? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 28, noes 11, ruled 36-1.
Ayes 28, noes 11, Rule 36-1. The Senate adopts the governor's recommendation with regard to House Bill 2168.
House Bill 2174.
Senator from Northern Fairfax, Senator Howe.
Mr. President, I would ask that someone else speak to this, as I don't plan to vote for it.
Thank the senator. Senator from Fairfax City, Senator Peterson. No? Anyone else want to field it? Okay.
Mr. President.
Senator from Southern Fairfax, Senator Barker.
Mr. President, I would suggest that you call upon the senator from Northwestern Fairfax, Senator Boysko.
Senator from Northwestern Fairfax, Senator Boysko.
Thank you, Mr. President.
Senator Boysko, do you have any recommendation for who I should call on?
Mr. President, I urge the body to support the governor's amendment and speaking to the amendment.
Senator has the floor.
Thank you, Mr. President. We had a good conversation about this bill in the general session in February. And I know that our colleague from Fairfax City looked at the bill and he believed that it would cause an undue burden for businesses who have part-time employees. And so it was his recommendation, and we passed an amendment that would eliminate employees who work under 30 hours. I've had a number of conversations with the agency and with the administration, and I have come to learn, while I will admit that I wanted the full bill originally, I now really understand why the bill was written that way, and I'd like to explain it to you all. Currently, we are facing a real challenge in the next generation of the lack of long-term savings by Virginians. And we are going to have a real challenge when it's time for their retirement because they haven't saved. We're going to have a burden to take care of. And so this has been done in other states where they allow the state to set up an IRA program. And the reason that it was explained to me was that it should go for part-time as well as full-time employees is, one, there is no mechanism in Virginia right now to separate out how many hours employees are working at different companies. So, for instance, if I have a company and I have 26 employees, I don't have to tell anybody that 10 of them work part-time, one works 15 hours, one works 12, one works 23 hours, and the rest of them are full-time. I don't have that responsibility. If we go down this road and keep it in the posture that it is currently in with the amendment that my good friend from Fairfax City asked for, we will be putting a burden on those employers that we're trying to ease of a burden. There is no mechanism, and they will be required now to go through and count how many hours. And what if somebody is working 10 hours in one business and then 15 hours in another, and then 7 hours in a third? That's over 30 hours a week. How will that be determined? So when I had the conversation with the agency, they made it clear to me that by design, the eligible employer is only responsible for facilitating an eligible employee's participation in this program. The employer's role is limited only to registering the program, a one-time requirement, and facilitating the worker's payroll contributions, a task which is already often delegated to payroll providers. In the unlikely event that you have a mom and pop shop who don't have a payroll provider, the bill has a component in here that says that they will help the employer face if they have an expense. There's some flexibility to help defray those costs. The employers have to make nothing. They make no contribution whatsoever. They are just merely responsible for remitting the saver's contributions to the program, and they're not required to take on any fiduciary burdens associated with this program, and the Commonwealth will provide the enrollment and the customer service for all of the participants. When we've looked around at other states that have done this, they have found that the vast majority, 80% or so, say that they're completely have no out-of-pocket costs and that this is not difficult at all. Another thing that gets really technical here, and I don't want to bore you all, but we've heard about ERISA, and there's been this question of, does this have a problem with ERISA or not? If we keep it at all employees, part-time and full-time, ERISA would not be subject. The challenge here is when we are cutting out certain employees, 30 hours or under, then you are having the employer make some decisions about it. And that is where the agency is concerned that we would be in conflict and violation. And they led me to believe also that it could end up costing the state. To go back to the point of putting the information in for the employees, employers are already required to provide this information to the VEC, so we're not asking for some new information. The employers already have access to this information. And so they would go to the portal, they would turn in the information, that would be the end of their obligation with this, and then the employees get to choose whether or not they participate. Again, there are people in this state who do not have access to a full-time job. They are basically, because they cannot get one, are forced to work sometimes multiple part-time jobs. We just were talking about the convenience stores, we're talking about the small mom and pop companies. Those are the people who would be helped. I received, and I believe everybody in this body received, a letter talking about the 150,000 workers who would would be involved in this requirement. And I think it's worthy. I think we want to encourage everybody to have access to a long-term savings account at no cost to employers and with the minimum amount of work that the employers would have to do. It is with that I ask the body to accept the governor's amendment. Thanks.
Thank the senator. For what purpose does the senator from Bedford, Senator Newman, rise?
Mr. President, speaking briefly to the
Senator's the floor.
Mr. President, anyone who is in business today knows how to count to 30 because they have to do it today. They count to 30 to determine how many hours you work, because either you fall in or you fall on the outside of Obamacare. That's the reason why it has been done. Mr. President, the other thing is this. If you do this, you're going to bring a whole host of small businesses into the administration of this. Even if those individuals, even if the employees are only getting 2 or 3 hours a week, they're still going to be included in this. Mr. President, we took a stand when we had the House bill. I really like the patron. I like the idea of a voluntary program. I think there's a lot to like about it. But the idea of mandating this on some of the smallest businesses in Virginia is a really, really bad plan. And I would hope that we would reject this amendment and go with the underlying bill.
For what purpose, Senator from Fairfax City, Senator Peterson, rise?
Thank you, Mr. President. To speak to the amendment.
Senator's the floor.
Mr. President, ladies and gentlemen of the Senate, I think it comes as no surprise I oppose this amendment, which basically strips out the amendment that we put in a month ago. And the gentleman from Bedford is exactly right. We had a very long and pretty laborious discussion on this, and I think we rejected what the governor is now proposing, and it's sort of like Groundhog Day. It's coming back again. As always, I take seriously what all my colleagues say, and I think the gentlelady from Northwest Fairfax makes some points, and I'm going to address them. First of all, this is a mandate on businesses. Now, if you have a business, and I know a lot of us in here are business owners, you have a 401k program, you're already subject to ERISA. And you know what? We all make that distinction between full-time and part-time employees. I see some chins nodding in here. The bottom line is, if I hire somebody and they work over 30 hours, I want to put them on full-time. They get paid time off, they get health care, and they get to participate in our firm 401k. If they come in and work for the summer, they work 1 or 2 days, they're part-time, they don't get those benefits. And you know what? No one's carrying me off in a black and white cruiser at the end of the day, because that's how business works in America. Okay? So why this distinction is suddenly impossible for people to grasp in the administration, I have no idea, but we make this distinction all the time. So that's for businesses which are already enrolled in a 401k ERISA program. Now what we're doing is saying, okay, if you don't have an ERISA program, because this bill only covers those businesses that don't have ERISA, we're going to erase that distinction and make you cover every single employee. You could have employees that park cars 1 day a week, or deliver pizzas 1 day a week, or babysit 1 day a week, and now they all have to be covered. Well, and I think, you know, we've had this discussion back and forth, and I agree with the gentlelady. This is not being driven by the law of ERISA. And I had a conversation with a very intelligent benefits attorney named Hank Kim last week, and he was an advocate for the bill, and even he admitted this is not being driven by ERISA. This is a policy choice. This is a policy choice. And we have put so many burdens on small businesses, and you know what? I'm going to put my hand up. I voted for a lot of them, okay? But to me, this is one too many, that you're going to take a small business or a medium-sized business, which has a part-time employee, could be a high school student, you know, could be a college student, could be somebody who's in for a few weeks, and you have to sign them up for a program because it's mandated. They have to opt out, but say they agree to be in the program, you have to remit the payment. You have all the administrative expense. For what? Again, this is for someone who's a part-time employee. We make that distinction all the time. And as the gentleman from Bedford said, the 30 hours is not out of thin air. That's how we make the distinction in Obamacare, whether or not you have to provide health insurance. So this is a distinction that every employer understands. They understand hours. Of course you count hours. That's how you compensate your employees. So at the end of the day, I just don't think this is a very good idea. I also note, and I had a conversation with my local attorney, Senator McDougal over there, there's no penalty in this bill. It doesn't say what the fine is or what the penalty is if you don't comply, which means under Virginia code it defaults to a Class 1 misdemeanor. So someone comes in, works for a couple weeks, they don't sign them up, and you're going to take them away in cuffs? I mean, again, this bill is just not well thought out. The original bill was smart. I think it had a targeted savings. This expansion is just not. Gosh, sometimes I wonder if anyone up on the third floor ever actually managed a business or owned a business, because sometimes I wonder. But the bottom line is, let's defeat this.
For purpose, Senator from Arlington, Senator Favola, rise.
Mr. President, I am going to speak in favor of the governor's recommendation.
Senator's the floor.
Thank you, Mr. President. I do understand that small businesses have some full-time employees and some part-time employees, but there are a couple of points here that I think we need to really remember. Most small businesses actually hire some company to do their payroll or to manage whatever benefit package they have, because they don't have the bandwidth to actually hire a permanent human resource person. So the question really before us is whether there's that much additional burden to just facilitate the opportunity for their part-time employees to participate in an IRA or some retirement program. It's all they're doing. And if they already have a process or they're working with a contractor who is doing this for them, I don't believe the additional burden is that great. Now, I also know that there'd be a slew of regulations that will probably come out. It'll be a very comprehensive process. Stakeholders will be at the table, and we'll be able to iron out some of the questions that have come up in this conversation. But I don't think the threshold here is so high a bar or so burdensome that we should just say it's not possible, especially when you weigh the other side of this. The other side of this is, the fact of the matter is, many, many employees will always remain part-time permanent employees. And this is particularly an issue for our millennials. They're out of college now. Many of them are working for 2 or 3 firms, they're on contract, they're gig workers, and this is how they expect to make their living. The days of going with a company where you're going to be a 40-year employee and that company is going to provide you with retirement and benefits and the safety net you will need are gone. They're just gone. So now we have a generation of folks who really don't have an opportunity to invest in their future, to provide their own safety net, to ensure that they will have a retirement. And what this will mean is the government at some point at a later date is going to have to step in and make sure that all these part-time workers who really never had an opportunity to have a portable retirement system will have a safety net, and the government will have to step in. This is a forward-looking bill which is acknowledging the reality of our economy today, the kinds of workers we have, the portability we need, the fact that your child and my child, they're going to work for 5 or 6 or 7 different employers in their lifetime. They may have 3 entirely different career tracks. This is our reality, and we're trying to take a step forward to say, okay, life's changing. We're going to have to come up with something that works better and for everybody and not leave everybody behind. This bill's not perfect. I'm not sure the governor's amendment's perfect, but he does have it right that we have to start looking at portability and we have to start acknowledging that there are some folks who will never be given the opportunity to really save for their retirement. I do hope we can vote for the governor's amendment. Thank you, Mr. President.
For what purpose does the senator from Loudoun County, Senator Bell, rise?
Speaking to the bill.
Senator, has the floor.
Mr. President, I'm going to oppose this bill, or oppose the amendment. As a small business owner, what we're going to do is we're going to make small businesses have an additional cost to take this out of payroll to send it into a central IRA. And, you know, look, I'm not against people saving for their retirement. I think it's a good thing. While we were having this debate and we're talking about how people don't have this option, Frank, that's just not true. You can go to Charles Schwab, you go to TD Amerihouse, you go to Fidelity, and all of them advertise they can open an IRA in 10 minutes or less. 10 minutes or less. In the time of this debate, they could have already opened an IRA if they wanted one. And these are no fee, no minimum IRAs, and they cost the employer nothing. So we're in a pandemic. Many of our small businesses are in trouble. 25% of them have closed. Why are we putting another burden on them? Passing this bill is a great first step without this amendment. After we get a better economy, maybe we can look at it, but I really don't think we should put another burden on small businesses with this at this time. Thank you, Mr. President.
For what purpose does the senator from Northwestern Fairfax, Senator Boysko, rise?
If nobody has anything else to say, I would just like to close it up.
Senator, has the floor.
Thank you. So let me just repeat again that there is a provision in this bill that if there is some sort of a hardship for a company, there are provisions to assist that company. Secondly, my good friend from Arlington spelled it out perfectly. The next generation of our kids and the millennials are not saving, although they already have the opportunity to go to, Ameritrade or wherever. They're not doing it. This is something that we can do to assist the folks so that when we are having to look at taking care of them in their golden years, they will at least have some sort of a nest egg. I ask the body to support this bill, and I thank you for your time.
Thank the senator. The question is, shall the Senate adopt the governor's recommendation with regard to House Bill 2174? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 11, noes 29.
Ayes 11, noes 29. The Senate does not adopt the governor's recommendation.
House Bill 2207.
Senior Senator from Fairfax, Senator Saslaw.
Mr. President, members of the Senate, House Bill 2207 is identical to Senate Bill 1375 that I explained earlier. That's the presumption bill that dealing with the death or disability of firefighters, emergency medical services personnel, law enforcement, correctional officers, and regional jail officers. This is where we ultimately agreed to move the date that it's effective is from July 1st of last year on. When the bill went to the governor, both mine and the House bill that you're seeing now had September 1st. He wanted March 1st. We agreed to a compromise, so the date is July 1st of last year. By then, most of these groups mentioned had the personal protection equipment, so the cost to local governments would be very minimal. So I would ask that you go ahead and approve the governor's amendments.
Thank the Senator. Do any other senators wish to be heard regarding the governor's recommendation on House Bill 2207? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The Senate adopts the governor's recommendation.
House Bill 2295.
Senator from Alexandria, Senator Eben.
Thank you, Mr. President. I move that the governor's recommendation for HB 2295 be adopted and speak to that motion.
Senator, has the floor.
Thank you, Mr. President. Ladies and gentlemen of the Senate, this amendment is the mirror image of SB 1381, which allows an exception for magistrates to carry a firearm in the course of their official duties. Right now, magistrates can carry the guns in courthouses. This has nothing to do with Courthouse Square. It just has to do with other government buildings. With that, I move that we accept the governor's amendment in the nature of a substitute.
Thank the Senator. Do any other senators wish to be heard regarding the governor's recommendation on House Bill 2295? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The Senate adopts the governor's recommendation.
House Bill 2312.
Senator from Alexandria, Senator Eben.
This is the House version of the marijuana bill with identical amendments to those that we discussed at length earlier, and I would move that we accept the governor's recommendation.
Thank the Senator. For what purpose is Senator from Eastern Fairfax, Senator Survell, rise?
Speaking to the bill.
Senator's the floor.
Thank you, Mr. President. Ladies and gentlemen of the Senate, in my comments earlier, apparently I used a word on the floor of the Senate that's never been used before. I received a whole bunch of texts and tweets at me about what is ganja. I just want to make clear I was talking about ganja. And according to Wikipedia, ganja is a Hindi name for hemp, derived from the word gaha, originally from Old Persian, the word meaning treasure, a powerful preparation from cannabis sativa. It's one of the oldest and commonly used synonyms for marijuana in the English language. So I just want to make sure everybody knew.
Thank the Senator for that. Do any other senators wish to be heard regarding the governor's recommendation on House Bill 2312? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 20, noes 20.
Ayes 20, noes 20. Right? Why not? No. Chair votes aye. But thank you for the input. I appreciate it. The Senate adopts the governor's recommendation with regard to House Bill 2312.
Mr. Chairman.
The junior senator from Chesterfield, Senator Chase.
On page 26, having voted on the prevailing side by which we voted for House Bill 2167, could we please reconsider that vote?
Thank the senator. Senator, I think we were just checking the records. It appears that the senator's vote was not on the prevailing side. The vote was, I believe, 37-3. Senator from Bedford, Senator Newman.
President, I move that House Bill 2167 be reconsidered.
Thank the senator. Question is, shall the vote by which the Senate adopted the governor's recommendation for House Bill 2167 be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? Clerk will close the roll.
Ayes 39, noes 1.
Ayes 39, noes 1. The motion is agreed to. Senator from Arlington, Senator Favolo.
Thank you, Mr. President. Mr. President, having previously explained the governor's recommendation, I ask that the body pass it. Again, it's moving up the date by which reports, the monthly reports that the parole board issue would be posted with all their specifications on the website. It's moving it up to December 15th, 2021. Thank you.
Thank the senator. Question is, shall the Senate adopt the governor's recommendation with regard to House Bill 2167? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? Clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The Senate adopts the governor's recommendation.
House Bill 2327.
The senator from Southern Fairfax, Senator Barker.
Mr. President, I move that we agree to the governor's recommendation. And just to make it simple for everybody.
There's the floor.
This is basically the same language that was in the section, the line that was stricken. The line that was stricken said that a state agency means any authority, board, department, instrumentality, institution, agency, or other unit of state government. State agency shall not include any county, city, or town. This changes the word shall to the word does, and everything else is identical to what was referenced in the bill when it passed. So there is no inconsistency in terms of what's in the bill, the way it passed the House and the Senate, and what the governor's recommendation is. So therefore, I move that we adopt the governor's recommendation.
Thank the senator. Do any other senators wish to be heard regarding the governor's recommendation on House Bill 2327? Seeing none, the question is, shall the Senate adopt the governor's recommendation? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The Senate adopts the governor's recommendation.
Mr. President.
Senator from Prince William County, Senator McPike.
I'd like to make a brief motion that we waive the rule, Senator Spruill's rule on taking out the trash, that we had adopted the rule, as you might recall, Mr. President, that the new guy take the trash out. But I'd like to waive that rule and suggest that we all chip out to the new guy from Tazewell County, and we take our own trash out, Mr. President.
Is there any objection? Objection. The senator has to take out the trash all by himself. Thank the senator. Do any other senators wish to be recognized? Madam Clerk?
Following up on Senator McPike's motion, we would ask that you take all your trash and get rid of it because we will be breaking down tonight and tomorrow. Please take all your personal items home with you because we will not be coming back to the Science Museum. But I don't know where we'll be.
Thank you, Madam Clerk. Is there any other business to come before the Senate? Seeing none, call on Madam President, Senator from Portsmouth, Senator Lucas.
Thank you, Mr. President. Mr. President, I move that the Senate do now adjourn, sine die.
Thank you, Madam President. Question is, shall the Senate stand adjourned, sine die? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The Senate stands adjourned, sine die.